We all do that. Welcome, old sport.
Thank you, ma'am.
Okay, if everyone read the minutes to the April meeting, if you have any corrections or additions, if not, I would entertain a motion to approve. Motion to approve.
Second.
Any discussion? All in favor? Any opposed? Carried. And then we have an agenda. I think two very interesting presentations. I call them tutorials, especially for me. If anyone wants to add anything, you can add it now. If not, we'll just go with the existing agenda. Any additions? Okay, very good. It looks like we're going to have a Brown Act presentation, and your name is as difficult to pronounce as mine is. So I'm going to call you Mike, and you may call me Mary Ann, okay?
Wonderful, wonderful. Everyone, I'm Mike Ciccozzi. I'm in the County Counsel's office. Ordinarily, Ed Knapp of our office for years has done these presentations, but recently he's been promoted to the County Counsel, so some of his duties have devolved upon the rest of us, and I got his duty. So put up with me, tolerate me. I won't make it too long. It will probably feel too long, but we'll try and get through it. It is, the Brown Act is interesting in that it was designed to bring transparency to government, and what it brought was a lot of litigation because the act itself is not always clear. So with that, we can start with the purpose of the Brown Act. And what the courts have said is the Brown Act is designed to facilitate public participation in local government decisions and curb misuse of the democratic process by secret legislation of public bodies. In other words, no more smoke-filled rooms. Though they were terribly efficient at getting things done, the backroom meetings, the meetings in the bars and down at FAT in Sacramento, it got stuff done. But the Brown Act was designed to show the public how these things got done, to inform the public. And interestingly enough, the state, when the state legislature passed the Brown Act, they didn't include themselves in the requirements of the Brown Act. So the state legislature thought that local government should be transparent, but we're doing just fine up here, so keep your nose out of our business. Not uncommon for the level of government drafting the law to exclude itself from the effects of the law. But the Brown Act seeks to strike a balance between public access to meetings of public bodies and the need for confidential debate. So you'll see as we go through this, there are some areas where public bodies can meet in closed session and exclude members of the public. Those exceptions are few and they are narrowly construed. You've got to remember that the Brown Act is referred to as a sunshine law, much like the Public Records Act. They became in vogue in the 60s when there was purportedly a great distrust of government. Interestingly enough, I looked at the statistics on trust in government. In the 50s and 60s, the people's trust in government was above 60%, at times peaking at 80%. Since the sunshine laws have been enacted, which were in part designed to enhance public trust, the public trust has fell below 50% and has not risen above 50% since the mid-60s, except right after 9/11. And we had a little peak that shot up above 50 and then it went right back to normal, right down into the 30%, 20% range. So whether that's related to the Brown Act itself and similar sunshine laws or other factors, which, I mean, a lot has occurred since the 60s. It's hard to tell, but I found the statistics interesting when you looked at them. Supreme Court Justice Brandeis, who had a way with words, said, sunlight is the best disinfectant. And that really is what the Brown Act is designed to do, to take whatever actions you take as a committee by making them public and open to the public, kind of imbuing them with this disinfectant, making them clean. And that's what it's all about. We don't want members of the public to feel that they are excluded from their own governance. And that in part is what the Brown Act wants to do. Now another part of the Brown Act is not just that the public has access, but it's it's designed to allow the free and open debate, but with respect. And that can sometimes be lost, especially when there is heated debate and when people are really invested in issues. You can see things devolving into personal attacks. The Brown Act wants to quash that, to avoid that. And it has several mechanisms, and we'll talk about those, to, when things get heated, kind of bring it down a few notches. So taking pot shots at people, that's not how public meetings should be conducted. If you want to take a pot shot at a lawyer, we're used to it, go right ahead. It bounces off us. But as for members of the public, we try to, and it's designed both that members of the public treat these commission members with respect when addressing them, and likewise commission members when addressing members of the public treat them with respect. So who's subject to the Brown Act? Well, you guys are. There's really no question that this body is subject to the Brown Act. The Brown Act itself covers the legislative body of local agencies, and it defines local agency very broadly. In fact, almost dogmatically. It defines it as a county, city, general law or charter, city and county, town, school district, municipal corporation, district, political subdivision, or any board, commission, or agency thereof, or other local public agency. So a local agency is a local agency in the end. Pretty much any agency will be under the Brown Act. There are very few exceptions. The courts broadly define local agency because they want a broad reach of the Brown Act. They want it to apply to as many agencies as possible. And that includes our Board of Supervisors and any subsidiary bodies created by the Board of Supervisors. All commissions, committees, whether decision-making or advisory, standing or ad hoc, and their respective subcommittees created by resolution or formal action of the legislative body. Now, this body was created back in 2006, I believe, by resolution of the board, and then you guys got a cool new name March of this year by resolution again, which in essence just restated everything, changed the name to Community and Economic Development from just Economic Development. So there, as I said, there's no question that this committee is covered by the Brown Act. The exception are advisory committees, which are comprised of less than a quorum of the members of the local agency. This applies only to ad hoc committees, and an ad hoc committee is a committee that doesn't have continuing subject matter jurisdiction or a meeting fixed by charter, ordinance, resolution, or formal action of the legislative body. Again, that would not apply to this committee. What that may apply to is, by way of example, if the Board of Supervisors selected 2 members to go out and take a look at some land in El Dorado Hills and report back to the board. You have less than a quorum of the member of the board. They're not going to have regular meetings. They don't have continuing subject matter jurisdiction. What they simply have is a direction from the board. You 2 guys, or in our case it could be Ms. Santiago, you guys go down, check this out, report back to the board. That's the type of ad hoc committee that wouldn't be subject to the Brown Act. Now, you'd be surprised what types of committees have been found to be subject to the Brown Act. By way of example, in Joyner versus City of Sebastopol, a proposed meeting of 2 members of the City Council and 2 members of the Planning Commission to interview candidates for a vacancy on the Planning Commission was deemed to be subject to the Brown Act. That was deemed to be a committee that was subject to the Brown Act. The adoption of a policy by the board of a school district to establish a committee appointed by the superintendent was deemed subject to the Brown Act because the authority of the superintendent to appoint people to the committee came from the board itself by resolution. So it was by a formal action of the board, and they said, yeah, we can reach through the superintendent even though he is doing the appointing and back to the board action. That committee is subject to the Brown Act. Once we've established that, okay, we are a local agency subject to the Brown Act, you get into a trickier area, and that is what constitutes a meeting? Because the Brown Act really applies to a meeting of the public agency. And this has changed over the years, and this is why I said in the beginning, the Brown Act, when written to help clarify things and make things more transparent, with the court's help and with lawyers' help, quite frankly, it has made things at times much more difficult. Now, a meeting was defined initially as any congregation of a majority of the members of a legislative body of a local agency and at the same time, in the same place, to hear, discuss, or deliberate upon any item within the subject matter jurisdiction of that legislative body or local agency. So in your case, the resolution sets out this committee is designed to do the following things, to look at the following things. So anytime this group gets together, or a quorum, a majority of this group gets together to discuss anything within that subject matter jurisdiction, and again, that is broadly defined. So even if it touches upon it, even if you rub up against it, chances are you got a meeting, you got to follow the Brown Act requirements for a meeting. It also goes beyond just what we'd consider a meeting where we all get together. It's any use of direct communication, personal intermediaries, or technological devices employed by a majority of the members to the members of the legislative body to develop a collective concurrence as to action to be taken on any item by the members. Now, this area, this particular aspect has changed, and we'll discuss that, but it's important to understand that the use of the communication doesn't have to result in any formal action for it to be a violation of the Brown Act. And that was in Frazier versus Dixon Unified. A violation was found where the members of the school district merely attended a work session regarding a curriculum controversy to watch a videotape about how another school district handled a similar controversy and to discuss how the district committee was handling their controversy. No action was taken. They watched the video, they had some discussion. That was a Brown Act violation. So you don't have to take formal action.
Question.
Yeah.
So if I sent an email to the members of this committee to discuss a particular topic that might be or may not be acted on later, that could be a violation of the Brown Act.
That's right where I was headed. So in I believe it was 2006, and preceding 2006, there was an Attorney General opinion. And in 2006, the Court of Appeal in Wolf versus City of Fremont decided that issue. And it did it in kind of a roundabout way. That case really had to do, the city manager was going from one member to another of the city council, and then the city council members had discussion among themselves. But what happened in that case is the court came out and said, well, even though you had those discussions, what you need to have is the discussions for the purpose of creating a collective concurrence among the members of the legislative body in order for there to be a violation of the act. In that case, they allowed the lawsuit to proceed because the person had alleged that there was a collective concurrence, but the court made that statement that you need to have that collective concurrence element. Now, the legislature took a look at that. It took them a little time, but in 2009, they passed Senate Bill 1732, which eliminated the collective concurrence requirement. Now, extrapolating from that, what they said in adopting it was that now a member of the legislative body cannot, outside of a proper meeting under the Act, through a series of communications of any kind, directly or through intermediaries, discuss, deliberate, or take action on any item within the subject matter jurisdiction of the legislative body. What does that mean? That means if you send an email about a matter that is coming before this committee to all the members of the committee, to a majority member of the members of the committee, you have committed a Brown Act violation. So you need to be very careful. You can send an email to another member, because at that point, there's not a quorum. It's just two guys on the committee discussing it. You can do that. But you have to be very careful, because once that email is sent to one member, that member can send to another member, that member can send to another member, and then we get into the issue of, do we now have a serial meeting? And a serial meeting occurs when you do just that. You go to one member, you have the discussion, and whether it used to be, as I said, you had to have that collective concurrence. You'd go to that other member and you'd say, hey, this issue is coming up, I'm thinking of voting this way and here's why, what do you think? And you get their buy-in. Then that member goes to another member, and that member goes to another member, and then the next member goes to another member, and so on and so on and so on. Guess what? You just violated the Brown Act. Same thing can happen with an email. So you have to be very careful, yes.
What if it's an informational to all the members saying, this is in a conference or event, I think we should all attend, or you may want to consider attending. Is that okay, or is that?
You have two issues there.
Okay.
First is the dissemination of information. Are you disseminating information on a particular matter within the subject matter jurisdiction of the committee? Chances are, if you're simply advising, hey, here's an opportunity to learn about something, the answer would be, no, that's not a problem, because you're not discussing, deliberating a particular thing within the subject matter jurisdiction of the committee. The other issue is, okay, how many members should attend any one event? Because, and we'll get to it, but you have issues if you have a quorum, if you have a majority of members at a meeting of another legislative body. And while their mere presence there may not be a violation of the Brown Act, you start talking about what's going on, and if that falls within the subject matter jurisdiction of your committee, yeah, you just violated the Brown Act. There's also the matter of public perception that you have to be aware of. If a majority of this body would go to another legislative body and all sit together, whether you're violating the Brown Act or not, the public perception may well be, hey, they're up to something. They're developing that collective concurrence. They're doing the backdoor thing, the backroom thing. So,
Could I take on that one?
Yeah.
For clarification. So, just this past month, there was an email that I wanted to send, and all of a sudden, in the back of my mind, I'm thinking, oh, I don't think I'm allowed to do that. So I didn't.
okay.
But it was informative for everybody. I think what I'm hearing you say is, though, that what would have been a problem with that is there would have been no public access to it, even if it wasn't anything that had to do with the public. Is that correct?
Well, even if at the next meeting, or whenever that item came up, I'm assuming that the information relates to a particular item that's within the subject matter jurisdiction of the committee, all right? And you wanted to provide this information directly to everybody.
Mhm.
It's efficient, I agree. It would probably benefit everyone, I agree. And our legislature has said, no, you can't do that. You cannot do that. Remember, the Brown Act was designed as a transparency law, not an efficiency law. It truly does make government less efficient. As I said, the deals in the back rooms, in the smoke-filled rooms, very efficient, very effective. You go get the deal done, boom. You know, when I first started practicing law, I used to meet with a lawyer for lunch, and boom, we'd get the case resolved, no problem. Well, that's kind of fallen by the wayside. That doesn't happen as much now. Now we go to formal settlement conferences and everything else, and it takes longer to get the cases settled. Whereas before, everybody knew, we knew what the cases were worth. We'd go, we'd have a meeting, boom, we'd get it done. Yes?
So rather than saying, no, you can't send that information via email, what are acceptable methods for sharing that information with the public and with the group? Would that be on a county public forum type of setting, or would it be,
It would be at a
what are the
public
options to
It
just
would be
do
at a
that?
public meeting. The other way things can be done is, and I don't know that it applies to this committee necessarily, but by way of example for the Board of Supervisors, if staff provides that information to each of the board members, that's perfectly acceptable. The Brown Act doesn't preclude staff from providing information. Obviously, you need that back and forth, but it does prevent the members from sharing that information among each other. You can't send it directly to the other members, to a majority of the other members.
So as Jeannie was saying, if she had something she wanted us all to be aware of, she should send it to Megan, who then in turn could send it to the group. Is that correct?
You want to be careful.
I don't want to talk to you. And
That's-
I was,
You know what?
this was, pardon me, I was going to ask a joke question, but now it's gotten to the point that I don't think it's a joke. If I invited them all to my place for a potluck dinner, I think I'd be in violation of the Brown Act.
If you had,
Unless we talked about the weather.
talk about the
As long as
weather.
it wasn't on the
Yeah,
agenda.
You can talk about sports, unless you're planning on bringing a sports team into El Dorado.
Yeah,
Sports stadium or
as long as
something
it's
like
not on the
that. We wouldn't be opposed to, but, yeah, you run a real risk of having, even in a social setting, yes, you run a risk of someone claiming that business was discussed there, and
So are they going to put you in jail?
No, Mary Ann, you just have to invite the public to
in
talk.
answer to your we'll talk about the penalties later. And the answer may be yes.
So if there was a blackboard, we at the university, we use blackboards for a lot of this. If there was a blackboard that was maintained by Megan, where anything like that went to everybody could be maintained and anybody could see that, would that be okay?
The answer, well, that's difficult to answer. However, let me say this. If the information is directed to a majority of the other members of the legislative body, whatever that may be, let's say this committee, whether you disclose it to the public or not, it is still a violation of the Brown Act. So if it is directed to a majority of the members of the committee, the disclosure to the public does not remedy the Brown Act violation.
You just answered. I'm going to take your question, move it up one level. Facebook. Okay, Facebook is open to everybody, and anybody can see what's on there. So coming back to the whole intent of this is to put things out in the open, but what you're saying is that we couldn't use Facebook because it's the same scenario of the blackboard.
I wouldn't use it. Has a case come down? Not yet. I haven't found an Attorney General opinion on it just yet. But given the legislature's reaction to the Wolf decision, where they said, hey, we don't need collective concurrence anymore, it is the discussion, deliberation of anything within the subject matter jurisdiction of the legislative body. I think you're running a risk. That's the most I can tell you right now. Yes?
I want to ask from a somewhat different point of view. Suppose everyone on this committee is on the Chamber of Commerce email notification list. So everyone is on the committee is getting that notification, but also going to everyone else on the Chamber of Commerce list. How does that interact with the Brown?
You're not precluded from getting public information. What you are precluded from doing is from a member of the committee directing information regarding a particular topic to a majority of the other members of the committee. So if public information is out there, you can access it. Yes, absolutely. What you can't do is you personally cannot direct information to other members of the committee. Yes, sir.
I want to go back to Jeannie's question because I want to take it one step further than Jeannie wants to get this information out. She gives it to Megan, who's staff. county staff.
Right.
What is now the responsibility administratively of Megan's Megan has that information now, and she's going to be disseminating it to the committee members, because that's what Jeannie asked her to do.
Right.
But what's Megan's responsibility to the general public for that piece of information, including if she does what Jeannie asked,
Right.
then does she bring it to the attention of this committee when they meet in session to say, this is the action that I have taken during this time period, so that that piece of information then becomes generally public? Or does Megan have a responsibility even before the next meeting of this group to somehow disseminate generally to the public that same piece of information?
No, it has to be given to the public at or before the time of the meeting, just like as part of the agenda. So you would have to disclose that information as part of.
So that's a
of
staff
the-
responsibility then, right? It's not Jeannie's responsibility to make sure that that was done correctly by staff.
Well, it is the legislative body's responsibility to ensure that the public has the information. Ultimately, it is the legislative body that is covered by the Brown Act. It is not staff level, it is the legislative body. So ultimately, buck stops here. You can't say, well, I told so-and-so to do it and they didn't do it. Now, that being said, you can correct these things. So at the meeting, you can make it available to the public. You make the information available to the public. Or, as I'll talk about later, there's a safe harbor provision as well. If someone's alleging a violation of the Brown Act, you have a certain amount of time to remedy it. So it's not the drop-dead hangman's noose comes down and you just put your head in it. There are some ways to remedy it.
Okay.
Yes.
I have another related question. Suppose a subcommittee is, say, working on a report to present to the committee. Is there a way that that report could be distributed to the other members for review prior to their next meeting? And how could that be done?
The report can be in advance, but again, it has to be disclosed to the public. It has to be disclosed to the public. Now, I think I'll stop there because then we can start speculating as to all kinds of scenarios. Yes.
What's the division between subcommittees that are ad hoc or standing?
I'll tell you what, that is a very difficult analysis.
That's why I'm asking.
Yeah, and I need a lot more facts
Okay.
to be able to determine. By way of example, I can tell you, we have in the county a loan advisory committee for home rehabilitation loans. And I was asked to look at it. Does that fall within the Brown Act or not? I tend to think it does. But in surveying other counties, some counties came down and said, yes, clearly it's Brown Act. Others said, no way is it Brown Act. So you've got to look very carefully at how the subcommittee was created. Who comprises the subcommittee? What are they charged to do? And you've got to take those elements and analyze each one vis-a-vis the AG, the Attorney General opinions and the case law that we have to ultimately take your, and really it is, your best educated guess. Are they covered by the Brown Act?
So there's been case law on subcommittees, and it's been relative based on what the context of that subcommittee
Yes,
is.
there is case law and Attorney General opinions on subcommittees. By way of example, the one case I cited where the board gave the superintendent the authority to appoint members to a committee to report back to the superintendent, to report back to the board. In essence, that's a subcommittee.
So I have two, and this might be helpful for all this. We had a very lively conversation at a Friday morning regulatory reform, which is held every Friday. So that's more of a standing subcommittee where it happens all the time. And then there's other subcommittees of this board that are more ad hoc. And the standing meeting on Friday morning, the question came up of whether or not this committee should be following the Brown Acts, and there was differing opinions. And then there was also the perspective of whether it was efficient and valuable. And so there's the legal side as well as the functional side.
Right.
So that's a question. That's the one subcommittee of this group that meets the most regularly, has the most effect and affect on stuff that are happening. And then there's other ones that are ad hoc committees based on whatever the topics of it is.
Right,
So-
and we'd have to look at it closely to really break it down and say, okay, how many members of the committee are on there? Is it a majority of the members? Is it less than a majority of the members?
Mike's responsible, so yeah.
The news goes over there.
Actually, that
Buck
that leads
stops
me
Mike.
to,
Yeah, exactly.
to a follow-on question, and that is, you know, I think as Howard mentioned, opinions will vary. Can we just come to county council and say, can you give us an opinion?
Absolutely.
Okay.
Yeah, we've had other
Because I don't think
committees.
any member of the committee can make the call, and I'm not sure the members of the public can necessarily make the call. And a lot of times it is, you know, outweighed by members of the public, and so.
And there are times where, sorry to tell you, the answer you're gonna get from us is, well, it's not a decided issue. Our best guess is yes or no. Depending on, and then it really becomes a policy decision for the committee, what's your risk tolerance? Again, we'll talk about the consequences of violating the Brown Act. Is it the end of the world? If you do it once, probably not. If you do it on an ongoing basis, it can have disastrous effects. Yes?
So just before we move too far away from CJ's question, getting to a solution, a possible solution. If I walk out of here today and tomorrow I find out some really great economic development activity or event that's happening before the next meeting, according to what I think I'm understanding, I cannot send an email to everybody telling them that this event is happening.
I wouldn't go that far, no. You can tell them there's an event happening. What you can't do is provide specific factual information regarding a matter within the subject matter jurisdiction of this committee. So, by way of example, if you become aware that there is this wonderful event, how to develop big box stores in El Dorado County, all right? And you want to tell everybody about it, for whatever reason. You can tell them about it. You can tell them that, yes. The preclusion is not, you can't tell any other member of the committee about any event or any seminar or conference, but what you can't do, by way of example, if there is a specific, I mean, one of the things you guys do is advise the board on a particular project, all right? If you come into information on that particular project, you could not disseminate that to a majority of the members of the committee. Or a particular regulation, or a particular, so it's not just anything that may have to do with economic development you can't discuss with any of these guys outside of a public meeting. But it is that type of specific information. Now, where that line is, you know, your guess is as good as mine right now. But I can tell you, if there is a specific project or specific regulation, and you want to disseminate information to a majority, the answer will be, you probably shouldn't do that. You'll be violating the Brown Act. If it's a more generalized type of information, not as specific, you'll probably be okay. So that's as much as I can give you right now as the courts sort this out. Because as I said, it was 2009 when the legislature said, oh, no, we're going to change this, so now it's any type of information dissemination or discussion, that falls within discussion, that will violate the Brown Act. So it was 2009, as we know, lawsuits move slowly through the court systems, so we'll start seeing cases that are interpreting exactly what they mean and how close you can get before you're violating the act. But I would say, as a general rule, if it's generalized information that may just touch upon things that you guys do, that's probably okay. But when you're getting down to specific things that are going to be considered by this committee, you shouldn't be disseminating that information to everybody.
I would think that the sensitivity in that example wouldn't be so much providing the generalized information, but when you sent that out to everybody, you could be inviting people to reply by saying, wow, this would help us to decide on, and now you've actually
Entertain the
Yeah.
discussion.
Right.
Yeah.
And so it's not the actual information, it's possibly how that might be handled once you hit send.
I
And
refer to it as the proselytizing piece.
Get that out.
Proselytizing a lot.
Absolutely.
Have there been any cases in Illinois County, legal cases against the county on Brown Act
On Brown Act
violations?
violations, we've had threats.
But never a
Brown
case
Act,
gone
but
forward?
you know what, I recall one in the last couple of years, and
How much time did they get?
quite frankly, when we got this was the safe harbor provision, when we got the letter and looked at it, we said, okay, because you get 90 days to remedy,
Gotcha.
and that's the way we handle it.
Your first infraction, you get 90 days.
Well,
Or multiple
not-
infractions.
it's
Is there a freeze policeman or what?
the public,
The public
typically the
police.
public, though the district attorney can.
We have a difficult time understanding it.
Who's gonna, well, you'd be surprised.
Okay.
People watch it closely, and you'll always have, as we know, in every county, in every city, in every municipality, there are going to be people who are really invested in the political process, and they watch these things very closely. So you'll often hear, if you listen to the Board of Supervisors in the open public forum, you'll often hear people get up there and accuse the board of violating the Brown Act, or violating this, or violating that. A lot of times it amounts to nothing more than bluster. As I said, I'm aware of one, and that truly did become a lawsuit when they wrote and notified that they believed there was a violation, and they invoked the 90-day remedy. We looked at it and we said, okay, just remedy, just fix it. And the board did, and everything was fine. I mean, there's nothing for them to do at that point. The Brown Act really just, it isn't so much about punishment as it is compliance. They want the compliance, not so much the punishment. That's why they drafted that safe harbor provision on. Just talking a little bit more about meetings, and I want to move on because there's a lot of stuff, but in 2011, the Attorney General issued an opinion stating that a majority of city council members could not attend a private tour of a water district facility which provides services to the city to acquire information about the services. So when you guys were talking about, can we all go to a meeting or something like that, here in 2011, which is a pretty recent decision, the Attorney General said the majority of these city council members going to the facility that provides services to the city to learn about it was a violation of the Brown Act. So you got to be real. Bottom line, you got to be real careful.
Right?
Yeah, go ahead.
If that invitation said that the public was welcome to go, at that point, then you would be,
You'd have to agendize it as a regular meeting, and now we're going to talk about what that means. You have to properly agendize it as a regular meeting, and yes, and the Attorney General went on to say, had you done it as a regular meeting and invited the public, even though quite frankly, it would have been a farce, and the reason I say that is because the city was in Southern California, the facility was in Northern California. So in truth, you agendize it, you tell the public, hey, we're going up to Northern California to look at the facility, you're all welcome to come. You know, you complied with the Brown Act, but I don't know how much of a public participation you're going to get. So, but that, you're not, as a local agency, as a legislative body, you're not obligated to drag the public, you're obligated to notify the public. What they do with that, well, that's up to the citizens and their amount of devotion. You may get a bigger turnout than you expect. So let's talk about how do we agendize. The first type of meeting is the regular meeting, this meeting here, and you guys did an agenda and laid it all out. You posted 72 hours before the meeting. Typically, it's done as you know, a hard copy posted to the outside of the building where the meeting's going to be. And it's also done electronically. And I saw your agenda, I just went right online and bing, bang, boom, found it without much of a problem at all. It should also be posted on the building 72 hours in advance. What does it have to do? It has to give a brief general description of each item to be discussed or transacted at the meeting. And this is done to inform the public of what decisions may be made. Typically, it doesn't have to be more than 20 words, but if 20 words do not convey the actual decision that may be made, then you got to use more than 20 words. It's not a hard and fast rule. What the statute says is generally 20 words, but if you need more than 20 to convey the true essence of what's going on, then you got to do it. And you can't bury things in there. And by way of example, you couldn't, or a legislative body couldn't say, this agenda item number 17, we're going to discuss the creation of a new water agency, and just leave that as the agenda item. But then, in the staff report or whatever else, the other actions to be taken as part of that are salary raises for any employees of the county who decided to join the water agency. Hold on there. Your agenda item that you posted doesn't inform the public that there are salaries or raises at issue. It only advised them that there was going to be the creation of this agency. You can't do that. You can't slip things in. Look, if you're not willing to tell the public what you're about to do, maybe you shouldn't be doing it. That's really, I mean, a safe rule to live by. If you think you've got to try and sneak it by, maybe you shouldn't be doing it. Interestingly enough, and this was little known throughout the state, and quite frankly, I don't know of any legal counsel that advised their legislative body, whatever it may be, the Board of Supervisors or a committee like this, to take this tact. But when they adopted the 2012 budget last year, 2012-2013 budget, part of that was this Assembly Bill, AB 1464. And what it did was it suspended the reimbursement for following certain provisions of the Brown Act. Now, when the state does that, what it means is the local agency no longer has to follow those mandated acts. That happened with the Brown Act for a short window, and it had to do with posting the agenda, giving the public notice of what you were going to talk about. There was a brief window there in 2012. That was cured at the November election, the November 2012 election, when the Prop 30 passed, and part of Prop 30 there was to reestablish the reimbursement for that mandate. Because if the state mandates that a local agency does something and it's going to cost the local agency money, the Constitution says, state, you've got to reimburse the local agency for that if it's a new mandate. If they suspend the funding for that mandate, then local agencies don't have to follow that mandate. So that's just a brief little glitch in history there. As I said, I don't know of any local agency that said, okay, then we're not going to follow the Brown Act because we're not getting reimbursed. It would have been a dangerous tack, but I could see some creative lawyers saying that that's perfectly legal. We saw it happen with certain mental health services where the state suspended funding, and so certain mandates did not have to be followed anymore, and lawsuits were filed to establish that. But now, even there are certain things that, even if they're not agendized, they can be discussed at the meeting. Some examples: members of a legislative body can briefly respond to statements made or questions raised by persons exercising their public testimony rights. So if someone wanted to speak in an open forum and ask questions of the committee, even though that's not agendized, it's simply agendized as open forum, a member of the legislative body can respond or inquire further of that person. The other thing, members may ask questions for clarification, to provide reference to staff or other resources for factual information, or request that staff report back to the body at a subsequent meeting concerning any matter. So you're not going to make a decision on it, but you tell staff, hey, I understand you're here today on this agenda item. I think there's a related issue. I'd like staff to come back with a report to us on that related issue. And then at that later time when staff comes back, we properly agendize. So you can have that type of discussion without agendizing it. Members can also take action to direct staff to place a matter of business on a future agenda. So you don't have to agendize that you're going to direct staff to bring back a future item. You can just do that at the meeting. There are also what's known as special meetings. There you have to post the agenda 24 hours in advance. You have to state the time and place. You don't have to have a separate public comment period to discuss matters agendized if you have a special meeting. There are also emergency meetings. These have to be true emergencies, and in those situations, if a majority of the legislative body determines that an emergency exists, they can discuss the item without need for 72 or 24 hours notice. They need to give 1 hour notice unless it is a dire emergency. Now, what qualifies as an emergency? They really mean emergency, guys. They don't mean you just sat on your laurels and now it became an emergency. They're talking about things like a work stoppage or other activity which severely impairs public health, safety, or both, a crippling disaster, mass destruction, terrorist attack. Again, simply ignoring a problem doesn't make it an emergency. An example, years ago we had a landslide on Highway 50. That required immediate action. We needed contracts, we needed to get things done. Another example, people will remember the Angora fire. That is a true emergency, and you can have emergency meetings, and I believe we did have 1 or 2 emergency meetings as a result of the Angora fire. But again, got to be a true emergency. Now, what exceptions do you have to the public meeting? They're known as closed sessions. Again, it's going to be narrowly interpreted by the courts, but the purpose is to allow the legislative body members to consult with staff and counsel in private, where the public interest in keeping the discussion confidential outweighs the public interest in participating in the item. Prime example, pending litigation. That is something that can be a closed session item. The board wants to get advice from county counsel as to what's happening with this lawsuit. Threat of litigation, if someone has threatened litigation. Obviously, they want to get their legal counsel in private because it is confidential. The attorney-client privilege exists, but if we discuss it out in a public forum, there is no attorney-client privilege. And sometimes you got to have very frank discussions. So you've got to have those in closed session. Some other examples, personnel, certain personnel items can be discussed in closed session. I don't think a lot of these would apply to this committee in particular, but I'm just speaking generally now. Labor negotiations, you don't want to negotiate out in public, probably not a good strategy. Same thing with real property negotiations. If you're trying to get a piece of real property, you don't want to have that discussion where staff is saying, well, we think it's worth $500,000, and the owner's sitting there thinking, all right, now I got $500,000 in the bank, let's see if I can get $750. I would have taken $400. That's really not the public benefit. It might be in that individual's personal benefit. So those types of things are closed sessions. I don't see a lot of them arising here with this committee. Could some? Theoretically, but again, I think that would be a rare occurrence. If you wanted advice from your legal counsel on a particular item, that could be a closed session item, but again, it would have to relate to either threat litigation or pending litigation. Otherwise, you just send a legal service request over to county counsel and send back the answer, or a answer. What are the rights of the public at the meeting? And this is where I was talking about civility earlier on. The Brown Act tries to invoke some of that. They have a right to attend the meeting unless they're being disruptive. You can't make them register or give other information as a condition of attending. They have a right to come in, they have a right to speak. They can videotape, audio record, broadcast the meeting so long as they're not being disruptive. Obviously, if they're running up, with the camera to get a zoom-in picture of every person who's speaking at the podium, that would be disruptive to the meeting, and you can tell them to cease and desist that. They have a right to all the documents. All documents distributed to all or a majority of the members of the committee have to be disclosed to the public. The only exception would be those protected under the Public Records Act. By way of example, a memorandum from counsel. If you asked a particular question on a particular item, counsel circulated a memorandum to every member of the committee saying, here's the legal analysis. That does not have to be provided to the public. That's protected. So the public can comment on any item before the board. They also have a right to comment on a period of time to comment on items that are not agendized, so that's your open forum. The board or committee here has certain rights, and they can put reasonable time limits on the right to comment. With the board, I'm probably sure you're familiar, it's 3 minutes for an individual, 5 minutes if they represent an organization. The board has the authority to, on occasion, say, I'll let you go a little longer, but they can also enforce those time limits. They can also have reasonable limits on rules of decorum. People running up to the podium, screaming, yelling, banging on things, you can settle them that. Tell them they've got to act professionally and respectfully. So you can control that. You can have those types of rules in place. The committee could also have disruptive individuals removed if they continue with their behavior. Now, that doesn't mean that if someone is criticizing the policy or a member or some of the services of the agency or any act, that you can have them removed because you don't like what they're saying. It's not content-based. You can't do it on basis of content. But it has been deemed disruptive to speak too long by being unduly repetitious or by extended discussions of irrelevancies. So again, you have some control over the members of the public when they are speaking. They got to focus on the issue, speak to the issue, and not just keep going over the same thing. Or you can cut them off. If you have someone who is being disruptive, the best act is to first adjourn the meeting. Take a break. Advise the person that they're being disruptive, that you're going to adjourn, and you expect when you return that they'll no longer engage in such behavior. When you return, if they continue such behavior, they can be removed and or arrested. And a prime case, I got a kick out of this one, McMahon versus Albany School District. A fellow was arrested when he was protesting. He lived near a school, and he was complaining about the students throwing trash on his lawn. So in attending the meeting to complain about that, he came in, he started his comments, and then he donned some plastic gloves and went to the back of the room and got garbage cans and started dumping garbage on the floor of the meeting. They weren't too pleased with that. Called the police. The fellow was arrested and cited out for disrupting a public meeting. He claimed it was his First Amendment right and tried to defend the action that way. The Court of Appeal disagreed. And they said, there are limitations to our First Amendment rights, and you crossed the line there, so you can't do that. And now what everybody's been waiting for, okay, what happens? You violate the act. What can happen to you? Well, there's civil lawsuits, civil remedies that can be imposed. That can be filed by members of the public or by the district attorney. And they can file it for injunctive relief to stop the action on a forward-going basis. So if you've repeatedly violated, you're not properly agendizing the meeting, they can get an injunction requiring you to do that. Or to void the action. Any action taken in violation of the Brown Act is void. So they can bring an action to declare that, whatever action was taken by the committee, to declare that void. However, and this is where we talk about safe harbor, before filing a suit to void the action, they must demand that the legislative body cure or correct the offending action. And you can do that by way of example. If you took action on an item that was not properly agendized, and someone sends you a demand saying you violated the Brown Act, it wasn't properly agendized, you can then, for the next meeting, properly agendize that item, and you can come to the same result, and you've remedied the Brown Act violation. The other, and it's always the kicker, because we lawyers, we protect ourselves, they can recover attorney's fees if they're successful. You don't get to if they're not, they get to if they are successful. So it's kind of a one-way attorney's fees provision. The other are criminal penalties, and the district attorney may seek a misdemeanor against any member who attends a meeting where action is taken in violation of the act and where the member intended to deprive the public of information which the member knew or had reason to know the public was entitled to receive. So that is a risk. I don't think we've ever had a prosecution for a misdemeanor violation of the Brown Act, but I don't think anybody wants to be the first, so to be careful. Really the bottom line in this is, again, public disclosure, and if you have any question in your mind as to whether you're going to run afoul of the Brown Act, then seek counsel. Advice of counsel isn't a defense, but at the very least, when it comes to the criminal aspect of it, the misdemeanor, which usually worries people the most, it is a defense to the intent element, where you intended to deprive the public. No, you didn't. You sought advice of counsel, and this is the advice you got. And so if you have a question, folks, county counsel is available to this committee, and you guys can see it. Focused legal questions. Please don't send us the legal questions that say, how many different ways can we violate the Brown Act? Because we don't have time to answer that question, nor could we conceive of every way that a legislative body could possibly violate the Brown Act. But you've asked some very good questions here today, and if you have, specific questions along those lines, those are good questions to ask. Yes?
A couple of years ago, I had to do some research on a new term for me. It was called electronic meetings. Can you speak to that and how that fits in with?
They're treated the same way.
Exactly.
They're treated the same way. And yes, our board, has the ability to do that, to have someone attend by video conference. But your posting requirement, you also have to post the agenda at the place where that other member will be attending by video conference. So it becomes cumbersome if you have too many locations where people are video conferencing in. But essentially, it's considered a meeting, it's still a meeting, and you have to follow your agendizing requirements.
I got about 7 questions for you.
Yes.
What constitutes, how many are on our committee? I'm wondering how many constitute a quorum?
According to what I saw, it's an 11-member committee.
So
Now, there are more than 11 here, but
So if we have 5 of us and we have a conversation, we're fine.
five of you is not a quorum. It is not a majority.
So we can.
6 would be.
The 5 of us could go to her potluck and talk about it.
5 of you could go to the potluck.
Okay.
We're gonna see who gets invited.
And some of your friends.
And it could be a rotating fire.
Okay, and then what happens if sometimes, let's say we don't have a quorum here and it's like, oh my God, we gotta make some progress. And so we vote here, we don't have a quorum. Can the remainder vote electronically and we get that moving ahead?
The answer is no. No.
Quorum has to be present.
Yeah.
Okay?
That's also a resolution.
So quorum must be present, okay.
What if we're running community meetings, some of us. We're out there, we're just inviting all kinds of people. And, or let's say in here, someone stands up and says, you're violating the Brown Act. Do we just like Is it like, woo, sorry you feel that way? Or is like, have we just crossed the line? Or have we crossed the line? It's like, holy smokes, stop what we're doing. We need to fill out a form. We need to contact county council. I mean, what happens if somebody says that to us?
Well, again, if someone makes the accusation that you're violating the Brown Act and it's completely without merit, let's say, you know, just based on what you know, and by the way, let me give you a resource. It's not the best. I looked online to see if I could find just a quick summary that I could hand out to everybody. Unfortunately, there really wasn't a good one. But the Attorney General has a Brown Act pamphlet that they created. Now, it's a little dated, so be careful with that information, but it's still a pretty good starting point for the discussion of the Brown Act. And you can find that at www.ag.ca.gov /publications 2003 Intro Brown Act. And that's a pretty good guide. Again, it's a little dated, being 2003. There have been some changes in the law, but it's a pretty good start.
So those who don't want to type that all in, I think if you do a basic Google search on Brown Act, that comes up on
You get
the top of the
a
list.
ton of stuff.
Could be the
Stay away from Wikipedia on the Brown Act. But a lot of government agencies have put out, by way of example, one I grabbed, it's actually not a bad one. It's a 2013, the Orange County Department of Education. Now, there are special rules for education, but again, it has a fairly good discussion of the basics of the Brown Act. So,
What is the bar for notifying of a meeting? You said 24 hours before, where the meeting's held, you have to post something before?
that's for special meetings.
What about, like, we're having these community meetings out there in Alvarado Hills. We just had one the other night, I can't remember. But what's our requirement for notifying the public of that?
I don't think your community meeting is covered by the Brown Act,
Awesome.
unless you have a majority of this body.
That's why I wasn't there too.
Awesome.
Yeah, if you're having a group get together at Casa Ramos, you're fine.
And I'm just, it doesn't say, if I hear you right, it doesn't sound like there's a lot of risk, given that in all the years in Alvarado County, there's never been a case, so it doesn't sound like a tremendous amount of risk. But have you seen examples of, I mean, I heard you up front, you were very clear, this was about transparency, this wasn't about efficiency. But have you seen examples? I mean, obviously, this is really inefficient, really onerous insanity to me. Have you seen examples of how people, how public bodies have functioned with this? I mean, or is it just, no, you just gotta have public meetings, just get over it. There's no email, there's no blog, there's no Blackboard, there's no nothing. People just have public meetings.
You gotta have public meetings. You gotta have them. And it does, and that's, that is a concern for a lot of different agencies, because some are dealing with some pretty contentious stuff. I'd imagine you guys do too, and you'll get members of the public wanting to attend. One of them I had to go to and almost mediate while discussing the Brown Act was RMAC, the River Management Something Committee.
Some of us were present.
Oh, okay.
Nicely done.
And thank you. I mean, some of these things can get pretty heated, so you got to have them, you got to live with them. I guess that's one of the joys of public service, for which we thank you. But it's part of the deal.
I have a question, but I'm not sure T was done with
Oh,
his.
I'm done.
7 or 11.
Done.
All right, I'm not sure quite how to express this, but okay, so there are commissions and committees and councils. And a lot of the examples that were given today, relate and are obviously relatable to the Board of Supervisors or the Planning Commission that has legislative responsibilities. But a group like this is an advisory committee. And so when I think of the Brown Act, it just seems intuitive to me that an agenda, 72 hours in advance. These things all seem to be intuitive and make sense and fair and the right thing to do. My question is that if the scope of the group is advisory and the agenda and the discussions are limited to discussions and not actions, is there any difference? I guess if you're not a legislative body and you're not making a decision and you're having a discussion that might come to this forum for a recommendation.
Right.
What about that other meeting? I mean, it was notified, the public was not only invited but encouraged, because you really want them into the discussion, because you'd rather not them surprise the process with information that hadn't been considered. That would be ineffective or irresponsible. And so I guess my question is, what is the difference between, outside of the notification aspects, when you're dealing with an advisory committee versus a legislative body? Because we're not a legislative body. Occasionally we make recommendations to the board.
Mike, it's confusing, the distinction you made, you said "we," and you're in, yeah, but who do you mean? Because I need to know, who specifically are you speaking about? CEDAC or regulatory reform?
Well, I actually mean both, because a lot of times what's on our agenda here, it is not intended to result in a decision or an action. We're just trying to share information. And so really, my question was for both.
Yeah. And the answer is, it doesn't make a difference. It doesn't make a difference. If you fall under the definition of local agency, and you do, it doesn't make a difference whether you're taking the final action or you're making a recommendation. It simply doesn't matter. You're under the Brown Act, you've got to follow the rules. Yes?
I want to defer to any actual members of this. Okay.
The public,
I'd
Mendel.
like some about subcommittee, where you said, I believe if I understood right, it could be less than half the members.
Yeah, let me get...
And that a subcommittee can meet, have a different type of meeting, if I'm understanding you right.
There are advisory committees which are comprised of less than a quorum of the members of the board if it's an ad hoc committee. Okay? That is the limited exception. And you got to be real careful in applying it. And that's why I say, when we're trying to evaluate, is this committee, is this subcommittee subject to the Brown Act, you really have to get in the weeds and dig in deep to find out.
I'd also like some additional clarification on the term subcommittee. I don't know that it applies to this group, but there's some other county committees where committees are described as subcommittees, but that have no members of the committee that they're described as a subcommittee to. So my understanding would be that they're advisory to rather than subcommittee of, but I'm not.
Well, and the exact legal relationship probably wouldn't matter for Brown Act. It sounds like what you're describing, though, as a subcommittee probably wouldn't be subject to the Brown Act because you're saying there are no members of the committee on it. So,
well, no, I'm thinking in this case, the group that's described as a subcommittee is actually appointed by our Board of Supervisors. So it's like the Trails Advisory Committee, advisory to the Parks and Recreation Commission. So it's an actual committee, but there are no members of the Parks and Recreation Commission. So I'm wondering about the subcommittee relationship.
That could well be. Again, I would have to look at, is it a standing committee, things like that to determine. But in answer to your question, it sounds like what you're telling me is it was created by formal action of the board. So if that being the case, you'd have to look. At it closely.
I would assume it was subject to the Brown Act. It was the subcommittee terminology that confused.
And you can call it apple and orange, but it's an apple. Lawyers try that all the time.
Okay.
So it wasn't really that, it was more of one of these, and the court just, and the judge will nod, and I've made the argument, and the judge will smile and nod. Okay. But it sure looked like it, man. It does look like it, but.
Are there any other questions? Oh, okay.
Okay.
One more question.
Sure.
Or two more, maybe. We have some board-appointed committees in the county that have no ongoing staff support at their meetings. Are there?
Okay.
That's a good question.
So I'm under the impression that in those cases, their chair develops the agenda and there is some support to get it posted. But
Yeah.
are there any particular issues for those committees that don't have that ongoing staff support at their meetings?
Staff support is not determinative of whether the Brown Act applies. So that would be, that wouldn't be part of the consideration.
Well, then for those committees, and I'm also wondering how the agendas may be developed. So could, in a case like that, would various members who might want something on the agenda be free to contact the chair and
Yeah.
say, please place such and such on the
And
agenda?
it could be, in the creation of committees, sometimes it's done by resolution. Some committees have bylaws that will spell these things out, and that's what you got to look at to see, okay, a default oftentimes is, well, we'll follow Robert's Rules of Order. I don't recommend that. They were designed a long time ago for a different time. It's easy to develop some procedural rules as to how you're going to go forward. And this committee, in the resolution, you have those types of things. This is how we're going to do it. So you can do that.
In Lindell's example, that they don't have staff support, but they have to notify the public, is it then the chairman's responsibility or the designated secretary or?
Whoever it is,
Okay.
they better get it done.
And so would this be posted on the wall? Let's say they don't have a website?
Then they post it.
On
You don't have to electronically, but you got to
Okay.
post it.
I'm not sure what
Well,
committees
I'm
the
thinking
county
of-
are not staffed. I don't
I'm
know
thinking
of
of,
any.
say, the Cameron Park Design Review Committee.
That's not
And I
county.
believe
Is that
that
part of
they
the
do,
CST?
I believe it is posted on the county
Well-
website, but they don't have staff
They-
at their
No, we
meeting.
appoint people to that.
Oh, we don't, okay.
We've never seen that. They should, I'm not sure.
Well, we're
I
county
think that they
appointed, we
post
don't
their-
have any staff. Staff in Springs Overall Advisory Committee.
They don't have.
I do the agenda, and then I had an agenda item offered by the public the other day, and I said, I'm not comfortable bringing that forward. All you gotta do is talk to somebody else on the committee. If they wanna tell me to put it on there, do it, and that's what she did, and so it then appeared on our next agenda. You've gotta be thinking about this, those of us who don't have anything out there, doing the best we can, so.
Yeah, as I said, the Brown Act wasn't as concerned with efficiencies as it was notification of the public. So yeah, it can be a hassle for smaller committees that don't have a lot of support. You got to do it.
But we also, I don't feel like I'm lost out there, because we use the county website, and we post our agendas there, we post our minutes there, and so I'm not so sure how much more stuff I want. So.
That may be a sentiment that's shared.
I spent it under Vice President.
Unless there are any other questions, thank you. It's been very informative.
Thank you all again. And if you do have the questions,
Yeah.
please do let us know.
What is the lag time between giving you a very structured question and the answer?
Forever.
Okay.
Let me answer.
Chances are the law will change between when you start the question. We try to get you an answer within 30 days. And usually we'll be in communication with you. I'm probably one of the worst at getting responses back because I like to be in court. So I get dragged into a lot of court cases, and then that of course pushes back the advisory. But we have a lot of much more intelligent lawyers in our office who write advisory opinions, and they can get back to you a lot quicker. And if I know, for whatever reason, I'm going to be tied up in some type of hearing, then I'll ask someone else in our office, hey, could you pick this one up? Because I don't want these people sitting on this forever, is an important issue. All right?
Thank you very much.
Thank you all.
Thank you, Mike.
Thanks, Mike. All yours, buddy.
Okay, now the controversial stuff, huh? Go ahead, Jim. Legistar.
Well, I am Jim Matrician, clerk of the board. I think most of you were here last time I was here. I just wanted to, we were gonna, on your agenda I had, we were gonna give you an overview of Legistar. I was gonna bring it up in here, and while Mike was speaking, I was gonna download it and show you, but it never downloaded, so that's my fault. I should have checked it before. But Legistar is really the tool that Megan would be using anyway. None of you would really touch it. You wouldn't have access to it. I was just going to show you kind of what she would have to go through, but I can speak to those points just as easily.
But for those.
There's a ton of committees and commissions in the system, but it's only going to give you options for those that actually post on the Insight page. This is called Insight. That's what we call it, that have content. You're right. So you could change it to Trails Advisory, for instance. And what it's going to do if you do that is it's going to bring up anything that happened last month with that. Then you could do a search for just those. It would reduce your searches. Reduce your results. I don't even think community would work in there. I doubt it, unless they had something in the agenda that showed it. So really all I'm here today to tell you mostly about is how to search for things and how you're going to find things going forward if you should decide to put everything in the Legistar. Is you would come to this page or the calendar tab to view your agenda every week. Megan would post it through the Legistar system. It would become available a minimum of 72 hours in advance to meet the Brown Act requirements. Yes, go ahead.
Maybe an example. For example, there has been in the past, someone would ask me, gee, when was the resolution of intention for the Camino community regions, okay? So, I would go to the search agenda tab. I would, not knowing what year it was, now I know it was 2009, but I would search all years and put the keywords into the search. And if you do the keyword, if you really get it well, then you narrow the list of things that come up. But here's where I have trouble. I have a document, happens all the time, bottom left-hand corner has a Legistar number. I just want to search for the Legistar number. And I have a very difficult time searching on a specific, now the Legistar number, you can get to a date, and you can go through the calendar on that date and dig that information out. But I want to know what's the right sequence of numbers or dashes, because a file number, Legistar file number has a dash in it, and so how do you enter the string appropriately? So again, the example is you've got a document. At the bottom right-hand corner has a Legistar number. You want to be able to go to that item and see what action the board took. How do I get there? That's my question.
So can you put the Legistar number in quotes? Of course, there are different versions of several Legistar.
It would still find it though. Let me get a number because I don't know off the top of my head that worked. How about that ag item? What is that, 130444? I might leave that open so you can look at it later. So you would type it into over my head.
I mean, I would think that would be really valuable for folks. When you find a document and you know that it went before the board, but you really don't know what action if any, they took on it.
So all I did was type that in, just like you see it on the bottom right-hand corner in the footer.
And it's a 2-digit year.
13.0444.
Just for the sequence.
13 is the year, and that's the 444th Legistar item that's been entered into the system since. And it just grabs it sequentially.
And that's it?
So that's it. That's the result. It was on May 14th.
Okay, now if you were to do that on the search agenda tab.
And I'm going to change all years because we don't know.
We don't know, right, in this case.
You might get a few more.
That
I didn't put it in. Didn't find anything.
See, that That's where I've had trouble. I think you might have gotten the.
Mike, that was gonna be my question is, when you do
Oh,
the
it's still
search
thinking.
agendas, when you do underneath the banner County of El Dorado, and you pick one of those, just underneath that banner up there, it says search agenda, what's the, items or something, what is it? What's that?
Agenda items.
Yeah.
Okay.
Your
Now,
search agenda items. is
now,
there.
when you had it over on calendar,
Mhm.
you still get the search, but what you get might be changed.
What you would get is just at a higher level. So search
Which
agenda.
one's
items-
higher?
The higher level,
Calendar?
which I still, like I said, I don't know if I like it yet, is on the calendar tab. What I'm recommending is people use the search agenda item tab. You have a choice, I mean, it takes 2 seconds to click over.
Mike, that's the one.
That's the one. That's what
Yeah.
you want to be able to do.
So I just typed 130444, and it took a little while, if you saw that green bar. And that's probably because it's finding, 5,000 things with 13 in front of them.
Right.
Or 13 somewhere in the box. So it took a few more minutes.
Now, if this item had, okay, so if you click on that, now you can actually get to whatever board action
You can
occurs.
get to everything that happened.
All the items
So
will
that's
attach to
the
that.
perfect segue in the rest of it. So what CJ Freeland was in the back was talking about is a version number. You may want to change that if there's more than one. The current version is what's going to show. And by version, I'm saying that an item like the Oak Woodlands Management Plan came back to board 36 times. So when it comes back that often, it's hard to track it. It is, the data's there. So, hopefully if you can do that much research, you can engage with my office and we'd be happy to help you, weed out some of that stuff. But you can, that's a bad example, but you can just change the version and it would give you the text different that went on that version, but all the attachments would remain, even if for different versions. So everything up here is probably going to stay virtually the same. The title would probably be different. The attachments don't change though.
Jim, speak to that version, because when this system was brought into the county, that was a big deal. The board wanted to collect information and not have it all over the place. So talk a little bit about that version.
So this isn't the best example. It's hard to find one.
Well,
But
go to any of the Lupu items.
Yeah.
the version.
Yeah.
Yeah, it's the 12 something series.
I can give you.
What's the file number,
I
Mike?
can give you a file number here in just a second.
It's 120265.
Yeah.
I think that's one of them, if not
That
the
sounds
one.
like one of them.
We'll wait for a half hour. It doesn't always take that long. This is a wireless connection down here. I don't know where it is. But what Chris is asking about is the version. So while we're waiting for that, if you have an agreement with your county, you have a contract with somebody, you have an agreement, they bring it forward, it's approved. 6 months later, they want to amend that agreement because they want to add compensation, change the term, whatever. We use the same file number that went 6 months prior, and we use a new version so we can keep all of that record together. Amendment, all the previous agreement, whatever's in there, you can go to amendment 4, whatever the case is, and all the content stays in one spot. That's really the reason, one of the primary reasons we chose Legistar, because it does that fairly well. Is it perfect? I don't think so. It's better than what it was before. I mean, you couldn't do anything online. You had to come to the office. And you had to wait for somebody to go find it. And it could be a long time, depending on where the material is. Did it ever pop up?
It's still searching, but I can give you a more specific file number. It's back further, but.
Here we go.
There it comes.
There it
Oh,
goes.
there it is.
That's not even
Department of
one.
Transportation.
I picked some bad one.
How about file number 11-0356?
Sure. Can we, let's do all yours because you're.
Yeah,
We'll get more results that way.
While this is looking, I have a technical question, actually.
Yeah.
Like on the agenda side, the agenda always shows up as a downloadable PDF file. Do you know if in Legistar, like, is this a more recent generation version of the software, or?
Tell PDF. Is that what you
The reason why I ask is because there's very simple technology out there nowadays to allow you to be able to embed that PDF file into the website, so that, one, you don't have to download every file to your desktop and have 16 PDF files that are sitting there before you get the one you want.
The way Legistar's built, no, it'll always be
PDF as an external file as opposed to PDF in embedded
Yeah.
copy.
Embedded.
And so this is a shrink wrap software you guys purchase and you just kind of use whatever
Correct.
they're giving to you. So
And
this
when
is a
they-
suggestion to the software company to change this
Right.
out to.
When the county purchased the Legistar, it was actually called, it was Legistar, the company was called Daystar, based in Chicago. And they were purchased by the company Granicus about 2 years ago.
So there's the results.
So there have been a lot of upgrades since then.
Why did you give the results, Mike, the 12? See the,
It's a related file, because I believe, and if you click on the,
I'm guessing it
if you
hit
click
the-
on the lower one, yeah, I think I can explain why that occurs. When there's such a huge number of documents associated with it, you're really begging the public to find a needle in a haystack, and occasionally the county, particularly when it goes from one year to another, creates a new file, and they show, so that it's not lost, a relationship to that file. And so you'll see the other one, I think, had a 12, because that went from, you know, all the documents that were included with that item up to 2011, and then 2012, there was a related new
See?
one that started.
That's what he's talking about. So when the department drafted this agenda item, it wasn't, this item is not directly connected to this item. So you don't want to create a new version of 356, because that would create more confusion. It's not connected. But they wanted to reference it because this is probably in 11356. That's why you got more than one result.
and then I noticed when you were on that first one, click on that again, you had an opportunity to go up there in the version and drop-down box.
What changed? Date of the meeting, probably.
And sometimes the time.
Title. Let's see what else was in there. Let's go back to 1. So 1 was this.
Also, it'll
See how all
add
the attachments stayed there, though? It's,
all of them, or does it add additional attachments that are the newest attachments?
I think they're all there.
They're
We have-
all there,
There's
okay.
40 there. Let's see what was in 7. There's 40.
Okay, that's good.
We don't drop them off because they're attached to the file. They're at the root of the file, the directory there. It doesn't change. But versions can be useful. I mean, that's why they're here, so you could read about what happened in version 4 when it went.
Is this your generating software as well as also your archival software? So when you guys put the agendas together and you have to post all this and create the paper for the board, you're generating it out of Legistar at the same time it's archiving, so you don't have a manual system you have to transfer.
I think that's what you were intending
It's
to show
all
us
one
today.
piece.
That probably saves
It's
you guys.
one piece that's, yes.
Yeah, saved a lot of headache in the
Right.
office, yeah.
Prior to Legistar, it was all paper. We had stacks. The office held 15 years or so. Then they would archive those by putting them in boxes and labeling them and putting them in the record center for another 5 million years because we don't get rid of it. And they're still down there. So if you ask my office for some records from 1984, it's gonna be a week or two probably before you can get it. With Legistar since '06, you can get most of it yourself, which is beneficial.
There was, I think it was your last meeting, I said that it was quirky. This gets back to the question how the software works. Drop down and show them the staff report portion that is down below the attachments. You see how that's set up with titles like body, see body, title? These are key words, and it's got to be crafted under that structure. And if it's not, it doesn't fit, doesn't function.
We
So
catch
this is
those.
where staff has to really be on their toes to
Right.
do Legistar.
We have templates, and Megan will have one too, to where when she clicks new, most of this stuff is going to be in there already for her. She just kind of has to fill in the blanks. The title is the most important piece. The title's what you're going to see on your agenda, so however you want it to read. When I'm looking at your agenda today for the item where I'm at, it would be that, if you wanted to say staff recommending CEDAC, if that's how you want to do it, then she would just spell out exactly what you're doing. It would just come out more like a board agenda than it does than this. You have another question?
Yeah, that train of thoughts. Okay, so at the Lupu website, planning services, long-range planning, they created a record of the meetings, the key meetings that have occurred. If we could go to that, it would be ideal. I think you might be able to. There you go. Okay, so if you scroll on down. Keep going right there. Now, pardon me while I stand up. Originally, these were intended to be a hyperlink to that Legistar item with all of that information. And originally, that worked really well. But those links change, and that doesn't really work. And, you know, I know that that was intended to really help connect the public to the information, but it's kind of a moving target, and I believe that there's a technical reason why that occurs, but what's with that?
Well,
how come that occurs?
I can tell you that. Those are links to those Legistar items. Every time staff has to go in to update those items, they're not accessible.
The
So
link
every
changes.
week,
The link, every time we do
that
a
would
new
be
version,
updated,
the link
it was
gets a new
basically offline.
address. So they talked to me about this before they developed the site, and I was still in the CEO's office at the time, but I was still the Legistar administrator. And I told them that's not gonna work. So they kind of went forward because this still has good information.
This is
good,
great information.
valuable, but for their intent to make a one-stop shop, to get right to the Legistar file, not really compatible. They don't talk to each other.
I believe it was a really good idea, and it's still very useful. And before, when I asked for clarification on how you search on a file number, so if the link is broken, at least it shows you November 14, 2011, that file number, and you can go to the file number, enter that file number, and still get there. It just takes another step or two, rather than just go to this page and click right to it, which is
This
the
page
original intent.
is manually maintained. Staff has to interact with these. This doesn't just happen.
And it's not so much that the link is broken, it's just that the link is not accessible to at the time because it's being used in the Legistar system.
Gotcha.
If you ever come to this page and you put in 11-0356 and all this page, the response is, please wait. Having somebody's name. We're preparing that item for another date. It's usually only like that for a day or two, typically.
It's
sometimes
usually
a
like
week.
that on Tuesdays when you're anxious to find out what's coming out on, what's the surprise
Because
on
then it's-
Tuesday.
Yeah, then it's active because it's
Thursday.
on the active
Somebody's
agenda.
doing
Thursdays, it's no good because it's being done for the next week's
All it-
agenda.
Right.
All it tells you is that your angst is justifiable.
Okay,
But
then
that's
how does
the-
it affect CEDAC and our agendas?
So
How
any
are we
other
gonna get-
questions on this part?
Yeah.
It's not really complicated. You just kind of have to train yourself on how to use it. But it's not hard.
It's those tabs that most people aren't aware of.
Yeah.
Like the one we're talking, because the default is
It
calendar.
defaults to calendar, and it defaults to calendar because probably 90%, if I may be so bold, just want to look at the agenda that's coming
Yeah.
out. They don't care about the rest of the stuff. They come here, they scroll down, and they click on the agenda, which is my custody.
They're not a micronolly.
They're not a micronology.
You know, sitting there at 11:30 at night going, hey.
So I
Night
advise
reading,
that.
Yeah, exactly.
Should be close. So to answer your question about why isn't my agenda posted?
Yeah.
I'm not in violation of the Brown Act. It's staff, not me. It's Ciccozzi's fault. Your meeting would appear on this same page.
Okay. And
You can
in
filter
lieu of
it
this-
if you don't want to read all kinds of stuff. You'll be in here. Actually, I might have.
Yeah.
Did I put delete?
Not
I think
yet.
I
It
took
wasn't
you out.
as of
I was in
yesterday.
there for a test. I was just messing around. That your name would appear here, and you can just you would just show those.
But it would be in lieu of this kind of a notification?
It wouldn't look like that. Well, it would be a PDF. It would look like the boards.
So in other words, Megan would send it out to her, greater email list of,
She won't email it.
Nope.
okay, so it's incumbent upon us.
That's the
to
other.
go-
The only other part of my conversation is
Yeah.
about the notification system. I think we touched on that last time. But it will look similar to this.
Yep.
It'll just say, the Community Economic Development Advisory Committee, it'll have all your names. And I think I put Mary Ann first, as I think then your vice chair, and then I just put the members. That's typically how we do it. Just like we have here.
Yeah, the same as Parks and Rec,
Drop,
Trails
but
Advisory.
Megan, I think we have Kim Kerr as the primary staff. You'll have the date, time, location, and then your agenda. It won't have as much stuff in there as the board does, but you can add to it if you want, I guess.
And Megan's CEDAC list, you could put a link in there, right?
Yeah.
You link it to it so that you don't have to embed the agenda or anything, you just put a link to it.
Should be able to add it to automatic subscriptions every time.
Right, so.
Yeah, that was sort of my question, yeah.
So-
Well, it's mine.
In order to, you're asking, how do I get that?
Yeah.
So I'll tell you, to the email subscription at the bottom here.
Oh,
This is on the board's homepage. Subscribe for agenda and minutes updates. Once you click on that, it's going to ask you to insert your email. And I'll put in one of my home email.
Okay, everybody write that
Down
down.
there.
Oh, it's Gmail, come on.
It's jsmatrician@gmail.com. And if I say submit, you're going to have to answer some questions. Immediately, in a couple years, when do you want these? When is it useful? Let me put that in again. I'm going to go walk through it so you can see it, because you guys need to know this stuff. I'm not telling you my password. Somebody's writing down the character.
Boy, you put down 9 bullet points as your password?
1, 2, 3, 4, 5, 6, 7, 8, 9. So once it's confirmed that your email address is, you put it in correctly, it asks you for the subscriber preferences. This is where you can select what you want to get from the county of El Dorado
good, so.
and that specific topic. We have it set defaulted to just a little bit of everything, I think.
Where was this found?
But they're all on there, like Parks and Rec and.
I think that we haven't, and we saying IT drives this is an internal piece. I think they have, the system called Bldg is what they use. So there are some, I don't know, some of you guys could get a lot of things. There are other choices, I think, if you know, depends on where you start. Got email subscriptions, depends on where you start. You can select.
Almost on each department homepage, there's opportunities to subscribe.
Right, you could, there, right.
As many as you want.
I don't do this, so, yeah, that's what I was talking about.
Yeah,
Perfect.
you can sign up for them all, man.
Megan.
You are dedicated to public, I can tell you that. I feel sorry for you.
I mean,
I used to do food.
Any questions on that? That's how you'll get them, and I encourage you all to do that. You would actually have to if you want to get it.
What will be the transition between old school and new school in Megan communicating not only with the CEDAC board, but there's a greater, email list that you now have to notify the public?
Well, I think that we could talk about that. I don't know, Megan, when you have some ideas on what you want. I mean, we could send a notification to that list.
Yeah, that's what
Saying, hey,
I'm saying.
FYI, effective the June meeting or July or whenever you want to do this,
June, yeah.
start this. We're going to start using it this way. Here's how you go in and get your email subscription. So you can get the agendas will no longer be delineated.
Yes, yeah,
That's what you would say.
But I mean, that communication has to be sent, because there's a vast amount of the
Oh, absolutely.
public that isn't
Yeah.
here.
But
to know.
wait, there's more.
Yeah.
There's already a link on the CEDAC page for the agendas and minutes, and there could be that link as well over to
Yes.
the agenda page.
Yes.
So people would be used to be going to that same spot, which they can do with instruction just to go over and to subscribe for
So in
continuous
addition
updates.
to a notification, when they go there to find it the old-fashioned way, they see that there's a link to the new way.
And maybe there's a transition time, maybe does that for 3 to 6 months, and then eventually
Which one?
we.
Keep going down, down. Yeah, in that area.
So this is where you post them now.
Yes.
And Megan might attach it to the emails that you do it, you actually attach the agenda.
She
Baby,
attaches
that
the
one.
link.
Your baby, that's why you do it. No, I'm kidding.
We like it.
So it looks like, actually, I don't know if this will probably, this is the same thing on the board's homepage, the same, that might have to come down to, because none of the, well, you can go a little farther with Mr. Van Dam was saying, is go pick after you enter your email address, but this is going to be specific to this page. And this page isn't going to be updated. So we'll formulate some really clean, compact statements so you guys can understand what you're up against. Mr. Smart.
I was just at the Park and Rec Commission, and we had some of the Trails Advisory folks there, and they have been trying really hard in South County to become part of the system. And I don't know whether it's, but a lot of them are in the dial-up stuff. And so they are just not getting it, you know, and if they're very important members of our community. So I've suggested the library as something, but somebody needs to be watching. Are we leaving people behind and they can't even tell us that they've been left behind?
They don't know. Yeah, guys.
I think it's a concern that everybody has, even the board, everybody. I would say that the board has been using this for 6.5, 7 years. And I personally haven't heard anybody say, I can't even get to an agenda. They can usually get to an agenda, they can't always watch the video live.
This morning the topic was,
streaming.
well, did you get the agenda? They said, well, I pushed it, and they got something. Now, sometimes you gotta say, there's gonna be really some operator error, I know. But the old system seemed to work. Agendas did appear, you know, like for the Trails Advisory, so folks knew what they were getting. Now they're being directed to a website that they can't seem to get it to do what's supposed to be done. Well, you gotta remember, it's a good chance, it's just like dummies like me that are trying to do this stuff.
You're right, and they're not, they're just not experienced.
At least we understand what you're talking about.
Can we edit that, Counsel?
I'm over here on some other subject.
You know, really, your users are just going to, you know, a website that links to another one. It's no different than shopping on Amazon. I mean, they can't always bring up everything, I'm sure. And I think that is why they left them as PDFs, and they kind of just left them open for people to download. I like the idea of what you were saying, embedding the whole thing. I probably will never do that. I mean, Granicus has thousands of clients, so they probably have to get at least the majority to want to go that way. But they have to make sure that they have Adobe Reader installed. You'd be surprised how many people don't.
Yeah.
It's like, oh, your computer should have already had that when you bought it, but they don't always have that. And Adobe Reader's free.
Darn that Windows 95.
The thing about that is if they click on the agenda that's a PDF, a screen should come up and say, hey, you don't have this, go get the reader for free. So it's one of those scenarios where, you know, government can't please everybody, but we really try.
Yeah, I would like to just help, you know, if there was some, because I've heard that now 3 or 4 different times at different meetings.
There's still the potential for them to get a mailed copy. Whatever department would probably charge them for it, but they could. They used to do it that way. The Board of Supervisors had a list of people that we would mail agendas to before any of this even existed. And that's expensive.
Well, Bob, we've got
hundreds of people.
We've got Jim's home email now.
Right. That email account is not
9 bullet points.
I use it for when I have to buy something on the internet and I get all the junk mail that goes on. Yes, Linda.
My question I have is, it looks like there's currently a place on the CEDAC webpage to subscribe to the agendas.
Mm-hmm.
And for folks who are currently subscribed on that page, I'm not sure if that's the list that Megan sends to, or how those people, will you be porting that list over, or will they have to resubscribe?
We'll find out.
It can be rolled over because we have the database of all subscribers.
Yeah.
How many?
500.
500.
Wow.
The Board of Supervisors has like 970. I wish there were more.
We've got 500.
You're popular. Any other questions? That's really all I wanted to talk to you about, just so you can kind of get an idea of what you're up against when you see your agendas posted.
It's been really good.
Okay. If you have questions,
I have
to
a
close on the
question.
Brown Act, you can read it. There's the government code.
Sweet.
If you want a horse's mouth, I'm a fan of the horse's mouth. Orange County education. I have it printed. I have to refer to it a lot. Yes?
For the meeting that will introduce the Legistar system, can it still be done both ways so that there's still going to be the posted and then the new one will be on Legistar just as kind
You
of
don't
a
want to rip the Band-Aid
crossover?
off?
I'm just thinking of it ripping slowly.
I don't see why we couldn't. All we would have.
It'd be the same agenda.
We would publish it on Insight and then we'd
Same agenda.
save a copy and post
You
it.
just print PDF master report on Legistar and use that as your posted agenda on the website and then make that as the introduction to the new
We can.
system.
Yeah, just do a transition period or something.
Yeah.
Just set it so that there's a sunset date for that, otherwise people will expect that.
Right, we'll just, in the email,
That
when we
month.
communicate, we'll tell them, we're gonna post it both for the month of June, maybe July if you I don't know, if you formally adopted this, I guess you have to.
Well, I think,
That's your discussion.
yeah, I think that might be.
This group doesn't
maybe
make
next.
actions, right?
Just to kind of close on it, it's not a flawless system, I mentioned that, Chris, but I think it works pretty well. We really don't get a lot of questions for information on the agendas. We get questions that are related to other things. So, are we done with this?
Are you the help guy? Are you the helpline?
Specify help.
If I'm in the middle of trying to do this and can't find out where I'm going, are you gonna?
No, not that email. No, that's the contact Michael.
Mike's tech support over
The
there.
notification system?
Yeah.
I can help you.
Yeah, I use Megan because that's an internal tool and she has
Okay,
access to
so-
IT.
okay, Megan Ciccozzi, okay.
If it's, once Megan gets up to speed, Legistar searching pages, I mean, I'm happy to help to any of my staffers, and then once Megan really gets up to speed.
So I'm assuming the old subscriptions did not carry over to Register, because I used to be on several of them, whether I was taking off consciously or not.
Well, that happened to me. I subscribed to the
Yeah.
Ag Commission, and all of a sudden I didn't get them anymore.
Right.
Gov Delivery's gone through 1,000 updates since they
Yeah.
put it in.
Okay.
It could have just got lost. I mean, it's only technology. We
So
can't
just
give it so much
reapply
credit.
or resubmit or
Yeah.
whatever.
You know, I think.
If you're not getting them and you should, then yeah, put it back in. And if you're still not getting them, then let somebody at the county know. We can.
I think something Jim said earlier in the discussion was pretty important because, just from one week to another, there was an improvement to Legistar that, you couldn't search from the calendar and then you could. And so, there are flaws with it. It's not perfect. But I think it's getting better. It's gotten better.
I agree. We live it.
Change is good.
So the idea of moving over to this, are there any overriding concerns or objections that anybody might have? Then I would move that we make this transition at a time when the county staff feels like they can accommodate the transition. That's my motion.
Do you have a second?
I have a discussion.
Well, we have to have a second and then we discuss.
Oh,
I'll second.
You gotta follow Brown.
Okay, is there a discussion?
Robert's rule.
so there's a question inherent in there, and that would be, how do we know when they will then get in touch with us and then we follow up?
Yeah, I'm suggesting that the committee decide whether or not we want to move in this direction. And if that is the case by vote, then I would say we would ask the county staff to tell us when they could accommodate a transition, and we would follow their lead there.
Any more discussion? If not, all in favor?
Aye.
Any opposed? 1, 2, 3, 4. Okay, we've got enough. We've got more to vote on it. Okay, very good. Thank you. Very important. One thing I haven't, since you had the Brown Act up there, the next item is about rescheduling the monthly meeting for us, because a number of members had difficulty attending. We don't have the members who had difficulty attending here now. So by notifying them of, vote on your day of the month to meet, is that some sort of a Brown Act thing?
Continue this item.
So we have to continue it, and they have to be here.
Yeah, and I just want to say that, some months,
So,
some months back, there was there was a request to change the day of the month that we have the meeting.
Well, it's, from the third Thursday of the month, either the first, second, or fourth.
Right. And I think, for the folks who were present on that day, that seemed to be a reasonable thing to do. But when we made that move, then we had some difficulties with some members not being able to attend. And so I think we were well intended, but I think we may need to roll that back, so.
Well, the classic is, it's the catch-22, that people have a hard time attending on this Thursday of the month, will not probably be here the next
You can
Thursday.
ask them
One of us
which
could contact
one
them
would.
and
They're
ask
less
them.
than,
You can ask them which one
but
would be
then you
better.
might,
On my note, make sure you don't
Yeah.
pass it on any further.
They are less than the quorum, though, so you could ask them.
They can submit their their information.
To Megan.
To Megan.
I was
To
gonna say,
Megan, okay.
yeah, people-
That- That's part of the resolution.
Okay, okay.
They could
They can't.
email it in based on this agenda item.
Okay, perfect.
They don't have voting rights, but they can put their input in.
Their recommendation,
So
and then we
input
can
is
bring that
allowed.
recommendation forward and then, and have a discussion and,
Right.
and take that action if so desired.
Okay,
Just to chime in here, my issue, and I was complaining a bit when the change was initially made, was that my calendar was adjusted, for 3-4 months ahead of time to Thursday mornings, and when we switched, then it took me 3 or 4 months to
Right.
adjust to something else. So I don't know if it's the same thing for those that can't make it, or they're never gonna be able to make it because they've got another commitment that can't be broken. We don't know. Okay. Well, what I'm saying is now that my calendar's more or less adjusted, so I'm going to
That's 3 or 4 months.
one of the people, dredging up my memory, one of the people that said she had a difficult time was Laurel, from the chamber, wanting to attend.
Oh, that's
But she
right.
had, I think, a conflict every month on this Thursday. So she's not a member of CEDAC, but at the same time, she's public that we do want to have here
Yeah,
and
she's okay.
communicating with her.
Well,
So,
she also provides the necessary information on, how things are going with the Visitors
Yeah,
Authority
exactly.
and the Film Commission and.
well, I'll tell you what, of the CEDAC members who are here, do you want to change? Would you prefer a different one? Or if you're in Dale's camp, that you want to keep it this Thursday of the month? So, Michael?
So my thing is, I'm okay with change, but I need.
You advance notice,
Yeah, that's
yeah.
right.
Yes, Chris?
Laurel is a member of the City Economic Development Advisory Committee, and when she can't attend, she just lets us know in advance that she can't be there. She attempts to try to be there, and so to try to get Laurel pinned down to a particular
Oh, I know,
day, I'm
I
just
know.
saying, it doesn't really work, she's busy.
I know, but there were probably 4 or 5 people that were giving feedback, probably illegally, that, they couldn't attend. I know it. ILLEGALLY, so, I mean, it was,
Well, the date
Just
that
send out
we,
the email.
the day, date, and times that we had before, I seem to recall that we had pretty good and consistent participation from Laurel unless there was something unusual. And so, it would be nice if we could get it back to something where she could attend on somewhat of a semi-routine basis.
Was that a morning meeting, Mike?
Yeah.
Was it?
Was it?
From
our mornings, just to get
12 on Fridays.
a consensus of idea, a show of hands, people who prefer the afternoon. People who prefer the afternoon, okay?
Oh, I'm sorry, is that?
Okay. Afternoon meetings is, yes, I know, you were talking out of turn. Illegally.
I tried to stop.
I know it, yeah. It's contributing to his delinquency. But, no, of the CEDAC member, well, everyone, because I do want the public to be here, because I think the input that they provide is valuable. Do people prefer morning meetings of show of hands? Okay. Okay, very good. Afternoon meetings?
But I can make either one.
Either one, or either one.
I'm
Thank you
either one.
so much.
But if you kept it on this Thursday in the morning, that would put us in conflict with Parks and Rec, which I have always attended.
And it also makes it very difficult for me because I'm taking minutes at the Ag Council meeting.
So it would
So
have to be.
it's very.
Guys, Springs Dorado Advisory Committee meets in about 1 hour.
You should just send out an email.
On Thursday?
You're
Yeah,
never
we'll
gonna.
send out an email, okay?
Yes, a full
And you'll just have to live with the consequences. Okay, and then the status reports as needed. Anything on regulatory reform?
I don't know if there's anything specific to report. Community meetings continue across the county. One this past week in El Dorado Hills.
2.
And then one yesterday in Public Pines.
Give us the flavor of one in El Dorado Hills.
The first one was incredibly well attended. There were probably more people there than I've ever seen attend any meeting. And this one was not well attended. I would say there were probably, 30 people there, probably 15 of us were involved. But having said that, it was a really good presentation, and it was a really good discussion. And I think that people that were there got a lot out of it. And the comment I heard the one negative comment I heard from everybody was, gosh, I just wish more people would have heard this, because it was kind of a foundational meeting that for, Mike did a presentation on, you know, the history that got us here, and Shauna did a presentation on Lupu and how that affects the community ID, and then Claudia did a presentation on the traffic model and how that affects things. So it was a wonderful, wonderful way to get people started, and
But as you said, it's foundation, kind of foundation
Yeah.
building, you said the framework.
yeah. But I will say, even though there weren't many people there, a lot of the opinion leaders were there. I mean, there were people there, I mean, you could look out in the audience and go, oh man, that dude is gonna go out and email 50 people. And you could look at, oh, that lady, she is gonna go, she's gonna have a meeting in her house with 30 people after this, you know? And so,
Not Brown Act.
yeah, yeah, so I think, you know, we just wish more people would come, but, you know, for what it was, it went well, and it was well received. And then we're gonna start the actual committee meetings, the subcommittee meetings on the different topics, and hopefully those will be well attended. We'll see.
Do you have a timeline, even a sketchy one? I mean, are you?
For, I think the first meetings of the subcommittees will probably kick off probably in June, I would think, is when most of the subcommittee people are itching to get started, and they were all ready to go a few weeks ago, and it was, people might be interested in this, that are doing other community meetings. There was this when everyone was all getting fired up and saying, hey, you know, we gotta get these committee meetings, everyone kind of stepped back and went, wow, you know, how are people going to contribute if they don't know how we got here, what the heck Lupu is,
Framework.
yeah, and what the heck the traffic model is doing.
Right.
And so we all kind of paused and said, you know, gosh, we really need to give people, you know, this is the box we're working within. And so it was, I would say it was a noble idea, it was a good idea. In point of fact, it's more proactive and educational than it is reactive. It's not Dixon Ranch is coming, how are we going to stop it? That'll get 300 people out. But this is like, hey, come get educated so you can be a better contributor. I mean, I don't know how many people you're going to get to a meeting like that, but we did it and it went well.
Well, and I wanted to comment too. It seemed to me that there was, you know, such a good turnout at your first meeting, and there was a really concerted effort by the steering committee to get everybody who was interested's emails into your system, and to put up a website to keep everybody informed.
Yeah, that's true.
And I think I kind of sense that, you know, maybe that's a sign of some confidence in the steering committee. The lower attendance on this one might have been the confidence of the steering committee, and the fact that the information is available and will become more available as the information comes forward. And so, but the folks that were there were really good questions. So it was very good dialogue. It was totally civil, which is always, you know, a win.
Okay, if it's on this subject, otherwise I have to backpedal a minute, but if
I
it's
want
on
to
this-
backpedal to
Okay.
regulatory reform. A big thing, and I just thought of it, Roger Trout spent 45 minutes to an hour, maybe longer, speaking about kind of broad perspective, historical perspective related to community, and I thought that time spent was probably the best time since I've been involved now, which is 6 months, that Roger's participation was very direct, and I thought, Michael, you could speak otherwise, but I mean, it was really good.
It was good dialogue. I was glad that we had enough folks there to actually have heard it.
And it was kind of like T just said, you wish the folks were there because, you know, it would have been able to disseminate the information about, well, the same thing happened at regulatory forum. I was just, that kind of information is invaluable.
Gee, is there gonna be another general meeting before the subcommittee meetings, or is the next meeting basically gonna be the subcommittee?
Well, I think it depends. There's about 6 subcommittees, and I bet most of them will meet before the next general meeting.
Is there gonna be an announcement of who's having those meetings and where will they?
If when the people that signed up on the email, it'll be on the website, and then the people that signed up for emails that had specific interest, they'll get emails
Is the
saying.
website the Facebook page, or is there?
No, there's a separate website.
It's, I want to say
CEDAC.
CEDAC-EDH.org.
Yeah.
Okay, Megan is my conscience. We got to the cliff and we didn't jump off, okay? On the meeting, we had I'll say it so I'm not saying it incorrectly. One thing is on the very last section of the agenda, it says date and location of our next meeting is to be determined.
So you need a motion on item C and then to include the next meeting date if you want to keep it at June 20th and with no changes, and then you're just continuing the item.
Okay, so a motion, I mean, we talked about just keeping June the same schedule, and then try to vote on it at the June meeting, with the understanding that, I guess, our registrar people will be told how important it is to come with their ideas about the date that works best for them. So a motion to continue having our meeting in June, same time, same place, etc., to add this on the agenda for the June meeting.
So
moved. Okay. Seconded. A second. Motion and second, any discussion? All in favor?
Aye.
So it's continued. Okay, thank you for being here. We appreciate it. Anything else? Other than that,
Yeah, there was one thing, there's a kind of a debate, well, kind of, we don't know what to do. The steering committee that's involved with something that happened in El Dorado Hills, and we're having a little internal debate about what happened, but when we get the committee together, what you find out is Lupu, you know, let's say it covers this much, and, you know, zoning and signage and, you know, covers this much. Well, you have a community meeting, you hear this much. And all of a
but
sudden.
that's why there are amendments to the Constitution. It's an evolutionary thing, you know, things get added.
Well, but they're talking about schools and EID and, you know, they're bringing up things that are beyond the scope of what we're doing in community ID, and we're trying to figure out,
There you go.
we're trying to figure out what to do with that.
Segue.
I would suggest using the Legistar capability and look to the presentation that Shauna Provines provided to the Board of Supervisors, Tuesday afternoon. It was, I think the item on the agenda was community ID, so it's easy to find. In the morning. If you watch the video, she really spends a lot of time trying to understand how, you know, what is the difference between community planning and community ID?
No, we understand that. What I'm saying
It's
is.
Lupu.
What I'm saying is, they brought up schools. Okay, so now what do we do with that information? We don't want to look like we're not following through on their concern, but at the same time, we don't want to take on schools. It's like, we don't have any jurisdiction, we don't have anything. Do we just say, sorry, you're out of scope? Do we refer them to the schools, you know?
So you probably weren't at the presentation that we did at the 10 to 12 meeting on Friday a couple of weeks ago. But we have a series of tools and processes that can help filter through all of that. And so if you'd like, I'm happy to get with you offline
Okay.
and show that to you.
Sure.
That's a good challenge, trying to figure out what is the scope.
Well, no, that part's easy. We know the scope. It's just that we're hearing things that are beyond the scope.
And you need
And
an
we don't-
appropriate way to either deal with it or say no.
Yeah, exactly.
I think there's a way to deal with
Or
it.
send them off to study it, you know. If you've got people who are interested, they should utilize that interest and try to come up with a solution on their own.
Yeah, that's an option
Yeah,
too.
yeah.
But, Mary Ann, I was just gonna say, this is a fundamental issue, and we've tried to tackle it many times. You're right on. To have a grassroots up, you're getting a broad perspective of what the community's thinking. And it's not a project specific like you would if there's a development project, but it's a more broad perspective. And so you're picking up topics now that they truly are interested in. And I think it's a job of this committee, because you didn't say otherwise, that you got to at least channel them to the proper place, because I would rather you be upfront with them and let them know than to try to mislead them.
Yeah.
Yeah, this is exactly what we need. I just kind of brought it up. I appreciate the ideas, and I'll take all these back. I just wanted to alert you for those that are in the midst, you might run into a similar issue.
Using reg reform as an example, I think the people who thought of it to begin with had sort of not a narrow vision, but they had a vision, and then because of continual participation, you know, there were offshoots, and Jim would say, you're interested in home occupation? Go study home occupation, you know? You're interested in rural commerce? Go study rural commerce.
And come back and educate us.
Yeah, come back with white papers.
But remember, reg reform even started with direction from the board, and that was based off of the 5-year review of the general plan. So again, you had a specific box that you were working in. You know, even CEDAC up the 2009 Economic Development Strategy Plan, you know, and specific marching orders in that 12-month strategy of, you know, what to accomplish. So still working within the box. You
Yeah,
have your
they don't have quite that
limitations,
framework.
but, you know, you're kind of adding new little boxes on the outside, which you don't want to squelch that enthusiasm and that participation, because that's, you know, that seems to be building in the communities, and it's really important. But to slow down the LUPU process is what I'm hearing is one of the concerns, not only of the
That's what my
board.
concern is. We're a little volunteer group. We've bitten off a big piece already. You know, we're trying to do this in a community of 60,000 people. And it's like, whoa, now we're going to tackle EID too? I mean, really? You know?
It does get overwhelming at times.
Yeah, someone brings up fire, oh my God, with all that's going on with fire districts in this county, it's like, to me, that's exactly my concern, is all of a sudden, we've bitten off so much already. Now, holy smokes, these could be black holes that get us way off task.
But but is there a way to still identify those concerns and set those aside? Because what you're trying to do is get a sign on it at least, you know, through the county process to finish the job that's been started with LUPU and
then come back and do those.
because it's a huge project, and it's kind of momentous that all this is getting done so well and so soon, and with so much cooperation from the community and the board.
Yeah, and that was my comment to begin with when I said about, you know, there are amendments to the Constitution. You got to get LUPU done, and that doesn't mean the book is closed with a lock. Nothing can ever change beyond that. After that's done, the sky's the limit. You can do other things.
Well, and that may be because the general plan is a living, breathing kind of document. It will go through another review. There will be other areas identified that need the same kind of attention that the first ones identified through the reg reform process have done. So it may be up to CEDAC to determine what those next steps are, what comes after reg reform, and to create that new little box where all those ideas and all those concerns are stored, so that those become, you know, the first topics of review when the next box is open.
Yeah.
Because that's a continual dialogue with the community about.
Yeah, and you don't want it to go away, because there certainly can be improvements in our schools and EID, and let's throw fire in there too.
And that's going to validate those community advisory councils that are coming out of this.
Yeah, because those are valid
absolutely
concerns.
validate what that group will be doing.
Okay, anything else about that? The other status reports I have here written, are any of these subcommittees still active? You know, business cluster retention expansion, incentive subcommittee, rural commerce subcommittee. I know they've all met at least once, but I think they're kind of dormant right now, unfortunately. I mean,
Mary, it was my understanding that rural commerce was kind of folded into the council.
it is, but I mean, it'd be nice to get even more participation on some of these. Some of it I think might be able to come to the fore after the LUPU process is done. So, are there any bits of news from the Department of Economic Development?
I've got a list.
Oh my goodness, okay.
Just to cover a few topics, some updates on the CEDAC board recommendations, where we're at with the grant development program and the cultural and community development grant programs. Both of those drafts for the RFPs have been written, and I think we're still just waiting on public input at this point. And Michael is leading a discussion on the 24th at the reg reform meeting.
We're going to have a 10 o'clock session. We're going to try to reconvene the group to try to get some focus and attention on those documents that have come out of the CAO's office for those two programs. Those documents have been widely published and are part of the distribution for our regulatory reform, so everybody should have access to those documents. It's important that we get some relevant feedback and closure on those so that they can go back to the Board of Supervisors for their approval. And once the board buys off on it, those programs can become active. And so, we had a lot of enthusiasm to create those programs. Now we have some documentation that outlines what those programs, drafts, what they should be, what they can be. We need to get those to closure.
Clarification on date. I thought I heard you say the 24th, that's a Monday.
No, it's a Friday.
It should be a Friday.
May or June?
May.
Next Friday.
Next Friday.
May 24th, sorry. Okay, good.
So that's our 10th, that would be at our 10 o'clock regulatory reform session.
And then we've also got the web portal development. We've identified a task team, and we're holding a working meeting on May 29th. We've also invited GIS to that because they have a program that might be useful for the web portal.
Who's the team on that?
We've got Michael, Howard, myself, Terry Knowlton, Kelly Webb with IT, Jose with GIS is going to be there as well.
Click on that one, Mike.
And I believe there's one other person, but the name is escaping me. Sue Henneke with finance and contracts. And then we just wrapped up the economic development budget, so we're beginning to put together the promotion contract extensions. So those should be hitting the board in the next couple months. That's the update on the recommendations. Were there any questions about those? There's not a lot of updates at this point. We're still working on a lot of it. And just to backtrack to April and some business walk updates, the Dorado Hills business walk, they completed that in April. The information is being written, the report is going to be put together by the Metro Chamber, and we should have that data in about 6 weeks. And so that information will come back to CEDAC for your review. We just did the California Camino business walk in the beginning of May. That information is also going to be reported through Metro Chamber, and that'll come back around the same time as El Dorado Hills does. So that'll be, we'll be able to look at both of them. I did meet with the Bldg Chamber yesterday, and they have expressed interest in doing a business walk as well. So that may be coming here in the future. The county did work with Sierra Vista Bank, and they provided a workshop for small businesses, and that was to focus on financing options available to businesses, small and large, and risks to consumers and businesses. And they also discussed business killers. They brought in a representative from Transamerica. And they provided a wealth of different information to anybody who attended.
Was it attended?
There was about 10 people.
I stopped by for a minute.
And
Stumbled
they
in.
do want to put on another event, so we're looking at doing one maybe down in the Cameron Park area coming soon. And they, some of the attendees also suggested doing workshops on employees and workers' compensation, and also business plan writing seminars. So we're looking at doing other kinds of seminars as well. And these opportunities are available to any institution, so I just want to make sure that that information is shared. We did have another financial institution show up at the seminar, Bldg. They're a nonprofit financial bank. They have a couple different programs that might be interesting, worthwhile to do a seminar on. They have a timber program, a timber loan program, a tribal loan program, energy efficient programs. So there are other options to look into as far as seminars that we can provide to the businesses.
What was the name of the second institution?
Safe, I have it written down, Bldg, and they're a nonprofit bank.
Did Sierra Vista underwrite that somehow, or how did it work? was their involvement?
They just came to check it out.
No, Sierra Vista.
Oh, no, they
Sierra
were just providing material.
It was
I
a
do
nice
have-
binder. It was very well done.
I do have a binder. I'm getting more copies, but this is the one copy that I do have. I also do have Ciccozzi information, one copy as well. I can get more though, but that's up here if you guys want to look at it. I can pass it around.
They talked about their business loan products.
This company
Yeah,
came to the
SBA
last Farm
related.
Trails meeting too and gave information to our members.
It's very well.
Safe Bidco, about 10 years ago, they were giving loans for energy efficiency projects. I haven't been involved in that a long time, but, so they've been around a while. I don't know how they are now.
Next up was Caltrans. They are doing a Gateway to Tahoe project, which is stormwater improvements. They are holding a mandatory pre-bid meeting in the Hammer Park CSD on June 12th, and that's going to be from 3 to 5 p.m. Flyers are going to begin circulating on this event next week. Again, it's for stormwater improvements. They're on the Highway 50 corridor. I believe it runs from Strawberry, Kybers, down to golf courses in Tahoe, so that's what area that's going to be covered. But they are meeting with local small businesses to connect them with Caltrans procurement process and contracting process. Their goal is to support the local economy, and they want to, connect their businesses with Caltrans so that they can use our resources. So that's happening, and I'll forward out the flyer on that when it comes in. And that's my update.
Thank you.
Good job, Megan.
Now, member updates.
I have just 3 brief ones. Parks and Rec, I was just going to turn over to Bob, but we met this morning, and it was basically trails and trains and trails, and the trains breakfast, fundraiser breakfast going to Latrobe. Thank you. Latrobe. I wanted to make an L out of that, but Latrobe will definitely be happening. There was a whole discussion the entire morning and a vote, and so that will be happening once a month, and at the same time, be looking forward to some of the safety concerns that the trails folks have. So it was a positive meeting. Visitors Authority, the big thing coming up is really the Cowboys and Cornbread event that's happening in July. There's lots of things going on, and I apologize. I told you I would make a list of everything that's happening and present that to you every month, and I just haven't gotten around to that. But this Cowboys and Cornbread piece is something for every single community to get involved in. There's place for everybody at this event that will be happening in July, so you've got plenty of time if you contact Jody Franklin over there at the county chamber, or come to our meeting. It's I think it's the second Thursday of every month at 4 o'clock at Moore. But the big one I wanted to talk to you about, 2 big ones I want to talk to you about. I'm just going to say real quickly, we did do our Pollock Pines community meeting last night, and we're just maybe, a couple, 3 steps ahead of T over there in El Dorado Hills, but we did get the beginnings after a lively meeting. We did get to the beginnings of our first community advisory council made up of 7 individuals that represent business, seniors, residents. We originally wanted 11, we got 7, so there'll be an outreach for the next 4, and the next meeting coming up for that, should any of you want to attend, will be June 24th. And Norma has been the facilitator, but it's important for me to remind everybody that Norma is the facilitator. There's a big difference between being the facilitator and being the community whose opinions and thoughts and ideas are really making that happen. Everything that's coming out of that meeting is coming from the community, and it's real important to know, from community up to government and not the other way around. But here's the piece I need all of the folks who are members of CEDAC to be giving your input on. At a Board of Supervisors meeting last Tuesday, there was somebody that got up and made a comment that it sounded just very, very strange. Maybe some of you were there, maybe you can comment on it yourself. But the comment was that CEDAC as a group doesn't have anything to do with business, that we don't do business, we don't do business. But as I look around and see who the members are, and if I look around and I see who the visitors are, the community people that come here, it seems like, obviously, that's what we are. We are here about economic development in the county of El Dorado County. So, but the perception is obviously there, or it wouldn't have been said. And so if the perception is there, I'm wondering what you all think about us having some sort of a comment. It doesn't have to be a presentation, but some sort of a formal statement to list maybe how it is that we involve businesses, how it is that we support businesses, how it is that we promote businesses. First of all, we're made up of several businesses. Second of all, we do a lot of things to promote businesses. So I guess I'm just asking for feedback. What do you think about doing that? If the perception is there, it's reality. Doesn't matter if you agree with it or not. It's somebody's reality, and if it's one person's reality, it may be more than one person's reality. So I've just got that open up for a discussion.
I remember hearing that comment, and as a business representative, I agree that I agree with you that a lot of businesses represented in this CEDAC have been for a while. I also understand why that comment was made. I think that publicly, because there's not a formal addressing of job development / business / economics, some people make that assumption. You know, a lot of the work that CEDAC's been doing for the heavy lifting's been doing for the last several months or years, I should say, has been LUPA, right, and planning, which many of us understand in the middle of this how important that is for economic development. And maybe that nexus is not something that's been articulated extremely well. And internally, I think that's not an issue at all. You know, people that attend all these meetings, you know, regular form, whatever, that's not. It's people from the outside that don't quite get that nexus between all the heavy lifting that you guys have been doing and the business side. So maybe that's what the statement addresses.
The role of EDAC is not to go to New York and recruit customers.
No, absolutely not.
Yeah, so promoting business, I mean, that's a broad category. SACDO and probably someone they're bringing on staff here is going to help either do attraction, retention, or expansion. That's not what we do here. You know, we're not a private economic development organization, so maybe that needs to be clarified. This is to provide a foundational economic development help for the county, or for everyone in the county, to constituents of the county, to promote more broad things and a foundation to help promote economic development in general. But we're not going to go place an ad in the New York Times or go to Germany with Barbara Hayes at a Sacramento solar company.
Well, and I think to that point, I think that in the past, that's what EDAC did. And that's what the Economic Development Department did. And so that transition between the old guard, you know, 5-6 years ago, and now is much different. And I would agree. I mean, I would agree that the way that EDAC or CEDAC is going now is much better to lay the foundation in general and not go do ads in
Speaking of old guard, maybe we should have T address that.
Well, you were there with him. Come on, Dale.
So you remember that 2009 economic development strategy I was talking about that was brought to the board where, you know, the reconfirmation of EDAC was established, and there was a 12-month strategy that was established that was also requiring an annual report from EDAC to the board. And when I'd asked Megan recently when we were preparing a grant application for economic development funds, whether there was an update or something on that 12-month strategy that was supposedly established in 2009, there was none to be found.
There's
So
a draft from 2012 that was never
I blame Mary Ann.
finalized.
So there may be some opportunities of things already in place that the group could revisit and reprioritize, and with the board's blessing, address two things at once, and make it clear to the public what the priorities are and the economic development efforts are of the group, and also to reestablish your marching orders for the future.
That makes
I recall
sense.
at one point we were characterized as a bunch of developers.
Yeah.
Too, so I don't know that we need to respond.
That's why I'm here, just to disprove the theory.
I don't know that we need to respond to any individual comments. I don't know in what spirit the comments were.
I mean, I keep thinking of the Buxton report and all those things, you know, the CSER or whatever it's now
Right.
called. You know, I mean, We've been dealing with that for years.
Right, and that's, again, the right information to the chambers and businesses to use,
Yeah.
not to go recruit, expand, or.
Right, no.
Along
But
with
even
Mark's
the
comments
businesses-
is that, I mean, we were trying to attract businesses a few years ago. You bring them here and all they run into is regulation issues and fees that are excessive. So once you finally get here, they go, what are you, crazy? You know, so I think really it's trying to change those fundamentals
Right.
first, so that now when we do go attract somebody, they will actually be willing to stay.
Yeah, and then we've been showcasing certain businesses within the county that have been a success story.
Right.
Do we have that young man coming?
Yes, it's the June meeting, the
The June
skateboard,
meeting,
yeah.
the skateboard, that young man that we saw, some of us saw at another presentation. Just, I think we have to keep upholding those good things that are happening in our county.
I like CJ's suggestion, and it was something I think
I
we
do
talked
too.
about in last month's meeting, that I think the only difference between the information that was provided to the board back when it said the annual report from CEDAC was that it was agendized that way.
Yeah.
Right? The information has been coming to the board pretty regularly, and it's pretty broad and pretty thorough. What we haven't had is the board agenda items say this is the annual report, and we need to follow through on that, and I think that's the process by which we answer those matters, and I don't think we should make a habit of dealing with individuals unless there's, something really significant that we've missed.
Okay. Any other
Yeah.
updates?
How do we do that, Mike, though? Do we make a motion out of
We're
this?
gonna, well,
No, you can
I-
just put it on a next agenda
Yeah, I
item
think
if
we're
you
gonna
want.
work with the CAO's
Okay.
office to make sure that the next time we do a really thorough review of the CEDAC items, that would include business showcase and, chamber items, that we need to make sure that the CAO's office agendize that as an annual report. And that way, when the public has that question, you can direct them towards the annual report. It's not like they're going through a whole bunch of documents that this one was just related to TOT, and this one might have been related to community ID. And where's the one that actually says, what's the whole range of things that the committee's been involved in? That's what we need to be able to provide the public, is a one-stop, this was the annual report, it covers the whole range, and then people can challenge whether or not it's sufficiently business-oriented.
It'd be nice if we could have a little trifold.
I don't know, I mean,
Yeah, you're going over into
You don't-
private sector's work, and
Right.
if you want to take that on, that's a lot of work.
Yeah, no,
a lot of
I-
What do you
money.
mean private sector's work? To make a trifold
'Cause
of
that-
who and what we are?
It costs money, and it's time
Well,
and effort.
But, yeah, I guess you can do something online saying, here's what we do, but
that's what our
T-shirts.
website says.
Yeah.
I mean, that's what the county's
Um,
economic development website says.
Yeah, yeah.
And I also agree with what Howard said too, is that, the public at large does not realize what Gordon said, and that is, you attract certain businesses, they come here to find out, there's an employment cap on the business park, there's regulations up the yin yang, and it's not that business friendly. Okay, so what are we doing? We're trying to make ourselves more business friendly, and as we see our way through the land use policy programmatic update, we really need to get on to that next step that Howard pointed to. And I'm not sure exactly what form that will take, but I'm pretty sure that we would be putting the cart before the horse if we didn't follow through with Blu in doing so.
On a positive note, I wanted to add, in the last month, I've been I went to that economic summit meeting in Loomis. It was fun, it was nice, it was lots of, Mike, you were there too.
Yeah.
I saw you there, yeah. And so there was some good conversation. It's true with most of those type of things. The great part of it is the conversations you have offline with the people you meet there. So, but what was interesting was a couple things. One of the presenters, or one of the MCs, mentioned about the future planning department. And he said, I just found out that El Dorado County is doing something with future planning. And I think that's a really cool idea. And then the second thing was, in one of the little workshops, somebody brought up, and I don't know who it was, but in the little workshops I sit in, said, I've heard that El Dorado County is starting to look into the future of what to do to make it easier to bring businesses there. And they're not from El Dorado County, they're from Sacramento County. I was like, okay, this is working. This is very cool. And then I was at another meeting with a bunch of investors, angel investors down in Sacramento, putting together a network. And one of those investors that didn't know me, doesn't know what I do up here, any of the things that happen there, also said that. And I said, well, where'd you hear that? And he's like, oh, a friend of mine that's like trying to do some land development in Folsom heard because he's talking to someone in El Dorado County. That made me start to think, that's the process you want, right? That's the viral grassroots rebranding of the county that naturally and organically will happen as long as we keep moving
And
positively.
it can't
forward.
happen in a trifold. It has to be word of mouth. It has to come from the.
And then I was going to say that in a really nice way. I was gonna say,
I really am the
bless
least
your heart, I
mistake.
like wrap cards and brochures, but it's not going to change people's perspective. What's going to change people's perspective is this viral marketing that will just naturally happen by word of mouth. And I was surprised to hear that after decades of hearing, oh, don't do anything in El Dorado County, that's a nightmare, right? So it was cool.
Well, the
It was cool.
interesting thing, Brent Smith from CEDCOR, Norma and
He was the one that was
Patty
presenting this,
Borelli and Kathy Pasilio Jenkins and I are on their board. And every month, we report what's happening in El Dorado County, and the people around that room were impressed. And a good percentage of the people who did the organization of that are from Placer County, and Brent was one of the organizers too.
Yeah, he was one of the
I think
presenters.
they're subliminally figuring it out.
That's what it takes.
Yeah.
So just wanted to share the positive influence that takes time. It is happening. You know, people are starting to talk. So.
And I think that part of what I presented down in El Dorado Hills had to do with the long history and complications of our general plan and how things began to change in 2011.
You know, I'd like to get, personally, I'd like to get some more of those things that we were talking about a few years back, the Buxton stuff and that stuff. I mean, my view on it is that, to Gordon's point, Lupu that's the priority. There's no doubt. I mean, if we don't fix that, then the rest of it is just a waste of time. But the reality is, for this group that meets here, a lot of that work has left this room. It is in regular form, it's happening in community meetings, and there's no reason why we can't get back to some of these types of topics. And so I, for one, I'm not ready to say what those are. I mean, maybe we talk about those at some point. But to me, getting some of those topics back here is not going to derail Lupu, because that's happening outside this room. I mean, we've done the heavy lifting there, and it's kind of moved on. But the other piece of that is, and I could be completely wrong, but it sure seems like Kim's handling of the solar company in El Dorado Hills, I got the impression that Kim really is doing a lot of this stuff. Well, I mean, I completely understand why she doesn't attend these meetings, 4-hour block, I understand. But I do think it's time to hear from her as to where she is on attracting business and business retention and what she's got cooking, what she's got planned, and a very candid conversation about, is there a way that we can support you, or is there something that we should be doing? Or, if she says, to be quite honest, to have a bunch of volunteers that's in the community trying to help out is more trouble than it's worth. We got this little department, it's humming really well, it's working, fine. We all just want business, I don't care, but to me, it would be nice to know what she's got cooking, and if there's a role for us to play. And I do think it would be good to get back to some of those kinds of topics that we were talking about before. We have the USDA in here talking about loans, we had the Buxton stuff, we've had other organizations that have interesting things that are happening, and Mark goes all over the place. My God, we should have him as a speaker sometime. What he's seeing in Fairfield and what he's seeing in Placer, and I mean, I think there's.
You may have some things in the offing.
But don't give it up yet.
No, it's fine.
But I mean, to me, I think it is time to get back to that stuff. And one of the other things too that is kind of a tangent of that is that I'm wondering about is I don't fully understand these groups that come before us, like the Art and Wine Affair and the Film Commission, and they come before us, and you can see it in their conversations. They're like justifying why they're getting the TOT taxes, and I'm like, I don't have the power to recommend or say yes or no, or, and so what they're doing here, I mean, I love hearing what they have to say, but if they think that I'm, if that, by them coming here means that CEDAC has anointed them for when they go before the Board of Supervisors, then I'm gonna start asking a lot more questions and say, what up about this, and prove this, and prove that? I mean, are we being used, or is there something we're supposed to
Or
be
is
doing?
there a prerequisite that they
I
do
thought
that?
it was in their contract.
It is in their contract.
Yeah,
But,
yeah.
but maybe that needs to change, because we don't have the authority to,
And we never do.
Yeah, and
You know, we
generally
never-
they come here after they've been to the board.
It's
Okay, so it's
informational.
not, yeah, it's
But they're
informational.
required to make a report and be accountable for those funds,
Yeah.
too, so you
But
should
not to
ask a lot
us.
of questions.
No,
You know, it might be a good idea to look at those contracts and see what the heck they are doing for you.
yeah.
I also think that
and
we have an
what they're
opportunity here
required
to bring the public in a forum that is not where the public gets to speak in 3-minute increments at a podium. And so I think it's an opportunity for those groups to come where there's a bit more interaction. Should we want to be proactive about understanding what their programs are and what impacts they are?
But I'm afraid they see it as a requirement because of what's in the contract.
I think it's both, actually.
So, I sort of have some background on what you were saying. I've been talking to Kim about some other things too, and you know, I don't want to speak directly for her, but for example, we're meeting with her May 22nd about some things, and we also have something else maybe later for this in July for this whole maybe for you know the CEDAC members and maybe a few more here, and I've talked to her because it's frustrating for me. I can't deal with every person here, every organization. So, for example, Placerville County has an economic development organization in Solano and Sacramento. So she is trying to pull all those things together to make it easier for the chambers and the business and the community. And so, you know, the new person's coming on, she's planning and developing that. And so she'll probably, within the next few months, talk more about that, I'm sure. That's exactly what they're doing, and I think it's taken a little bit of time to pull it together. But I do think that this organization would make a mistake if you know you go too far in that, because you need huge budgets and professionals to do business, real business attraction, and Sacramento's doing this next economy. There's hundreds of thousands of dollars of sponsorships and everything put into it, and they're looking, using Ryan from CSCR who did that report back whenever year it was for us. So they're doing all this, and they're looking at everything from advanced manufacturing to ag tourism. And so Beacon Economics out of Los Angeles, Sacramento Bee uses them, a lot of people use them as consultants, said, okay, it's great you're doing things, but you're not going to be Silicon Valley. Don't, you know, that's, you know, you're not going to go, they're better. They have Stanford's there and Berkeley and Lawrence Livermore Labs. You're not going to beat them at their own game with thousands of students pouring out of those universities. And talk about investors. Our investment is this much in Sacramento region compared to the Bear. So don't beat them at that. You know, try to create a foundation, which I think we should do, that rises all ships. And concentrate on what you're good at. So in Sacramento, the guy from Beacon Economics, and it was in the Sacramento Bee if anyone wants to look it up, it says, you're good at ag. Like, people don't realize this whole valley, you know, starting here and all the way down there. We're like number 1 or 2 at all ag products in the United States, if not the world. So they're saying concentrate on what you're good at ag. Government is not a bad thing. You're strong at government. You're government-centered. You know, get the STEM research thing here instead of San Diego, things like that. So they're saying make it a better place to work. The other thing they brought up was reducing time for permits and regulatory. I mean, that comes up, if you can master that, you know what everybody says. So doing those things, and I don't think anyone here, you know, well, I don't know it's a little one, but you know,
Go ahead.
There's a reason Barbara Hayes in Saco makes $240,000 a year. So we're not here to do that. I don't think we have the means to do it or the money to do it. So they're professionals. But get the tools and the foundation like the Buxton study and the CSCR stuff, and then give it to the business people in your community to do what they do best, not us.
I agree with
Do you
that.
think there's
Yeah,
a role
they
for
need to
us?
be holding that.
Yeah.
Do you think there's a role for us in trying to digest next economy? Because that's region-wide, and it's, and, you know.
Yeah, there is a,
I know we're a part of it, or our board voted on it.
Right, Charlie is a goes.
Charlie, report on it.
Yeah, anyone can participate. The small, and there's a big, huge difference, and that's why it's my idea. There's 13 regional workshops, like in the Gold Country's Prosperity one was sort of small. It's more small business and things like that. But, you know, again, you do what you're good at. The Sacramento one's coming up, and I'm going to go to that, and that's going to be a little bit different. So the next economy is sort of part of that, too, part of a statewide economic development effort they're putting together. So there is a place here, but I think you go through Kim for that and the staff person that they're going to hire to do that. Give them the information and let them be the professional. And at some point, this whole county's got to decide, you know, how you want it. You have a good point about attraction and retention and expansion. Well, you need to utilize SACDO for the big stuff because that's what they do, and you're already a member, right? So, but what role these people, you know, or these investors that you work with, they're not going to deal with the Shingle Springs Chamber of Commerce, the El Dorado Chamber of Commerce, the El Dorado County Chamber of Commerce. At some point, the county's going to decide, we're all listening together. We're going to attract them to the region through this one organization. And right now, to me, it seems like whoever's going to get hired here and is going to work with Kim is going to be sort of that person. Now, it could be you guys get a bunch of money together and develop your own economic development organization, but I don't know. I don't think that's the way to go. That's just my personal opinion. So I think then you funnel all this great information you're talking about and that we should do. And then when someone comes, you know, they give you 2 days notice, they're flying in from Japan and they want to do a seed research and development manufacturing and they're meeting at UC Davis, then that person from El Dorado County, you don't fight over which chamber person goes or whatever. So that person goes and then gets the information, comes back and gives that, all right, I'm looking for a 5-acre site. They need to be close to railroad tracks. And Kim, representing El Dorado County or whoever, comes back and sends it out to all the different chambers or the business communities and says, here, you want to submit a bid or do you want to go to the governor's office, CalBiz? Here it is, it's confidential, bid it. I think that would be one really good option here because I don't think the individual cities, counties, and chambers are big enough or have enough money or the expertise to do that. So, and that's how they do it in Placer County, and El Dorado County and Placer County are very similar. So, I think that will be approached, and I think Kim's doing a good job on it. It's taking a little time to get out.
And working together, you know, because we can't do it individually. I think working together in everything, you get better results. So, Chris?
I think Keith's points for this meeting is very appropriate because we've been talking about Lupu and beyond. It's that beyond now, which I think comes down to what is CEDAC going to be doing? What's this group going to be doing? Because you got regulatory reform and there's a lot of effort that still needs to be done, that oversight, making sure that things move along and that Lupu gets approved. But this question about what this group does on their monthly meeting is very relevant, and after 6 months of being here, I can see where there's been people that have been here that I found very interesting, that they were almost like trying to market what it is that they do in order to be able to sell something. Well, if that's an authority that CEDAC has gotten, regardless of how they got it, then that's a good thing in one respect, is that you're going to get people with information and you're going to be able to know exactly what's going on. And this is the forum to ask them those questions if they can't do it at the agenda, in the agenda at the Board of Supervisors. But I find it very interesting that today we had two, almost like we're beginning over, because you had Brown Act and you had Legistar, and it's almost like, okay, administratively, this is what you need to know in order to launch an activity. And here we are with that kind of a day. So I think how it turns out is the responsibility of you as the CEDAC voting board members to kind of figure out where you're going to go, because I find it very entertaining, and the discussion that you just had, is it Mark?
Yes.
Yeah, that you just had is very important. It's more of a kind of a regional kind of a play. So I just wanted to say that, Mary Ann.
Okay, very good. Anyone else? We've got 5 minutes to,
I think a key for us to move ahead is we're gonna have to move the meeting to a time where Dale can't be here.
Can't shake me.
We know your vulnerability, there's some, you need time to react to your calendar, right?
okay, any
So
other?
just a quick report, the college is graduating next Wednesday. Our enrollment for summer and fall is actually down. It's a surprising trend. Yeah. I said in an earlier meeting, we've got 6 or 7 things in play. Inflation's gone up, it's hard to get financial aid, students can't repeat courses like they could in the past. We've clamped down on how many units they can register for. So all those things are going on. We're not sure if one or all of them have discouraged enrollments. But if you've got young people in the house or grandkids or whatever, it might be time to take another shot at the community college. So we've got some capacity, and with Prop 30 passing, we may have some financial support as well. At least we're stabilized for the meantime. Budget situation looks a little better at the state level. So anyway, we're really busy leading up to graduation. But if you want to come take a class, think about it.
Good. Anyone else? Then I've done my job. We're out of here on time, okay?